Minister of Religious Affairs, Government of Pakistan.
Mr. Landau.
Thank you, Your Lordships. Can I begin by setting out my proposed course?
Yes.
I'm going to leave the facts. I have one observation to make, first of all, on the facts, which is just to complete the story of the Pakistan proceedings. I just want to mention the 1990 proceedings in order to finish the sequence, and then I'll move off that.
Yes.
It seems to me that you've had enough on the facts, and the point, perhaps, if I may focus it for the court, is that Mr. Justice Aikins and the Court of Appeal have already had thorough reviews of the facts, and the question...
Well, I mean, one could take the view, couldn't one, that there's a concurrent finding by these two courts on the essential factual points. We don't need a lot more.
Exactly. And indeed, the only point really for this court is, was the test incorrect that was applied to those facts, namely the review?
Yes.
So I will then focus on 2 points, which will encompass the menu that was provided for me yesterday. Firstly, the nature of the review.
I think Lord Savile's already, I think, hinted at the word review may be unfortunate.
Yes.
So it's the nature of the exercise
Nature
which
of the
is required
exercise.
to be carried out.
Nature of the exercise to be carried out. In the course of that, I wish to come back in a slightly more methodical way to explain competence within as relevant to that. Secondly, transnational law.
Yes.
That's all I'm going to cover.
Very well. Thank you.
In order, firstly, to complete the factual story, the one area I wanted to bring to your Lordship's attention, which was not covered in my learned friend's survey, was what happened after the 1998 proceedings in Pakistan. And I can do this probably just by giving you references rather than asking you to take up the bundle. You will recall that in 1997, the first set of proceedings began in Pakistan. That was the same day as the letter of termination, January 1997, 20th of January 1997. You've been shown that. You will recall the position that was put in those 1997 proceedings, and that it ended up with a judgment, a short judgment, that invited the claims to be, in their words, agitated by the government instead of the trust. That was a false lead by the learned judge in the court in Pakistan, as it turned out. And you have already got our points on the significance of those 97 proceedings in terms of understanding the letter of termination. Now, what then happened was the 1998 proceedings, which you have been shown. What is significant about those proceedings is that they were commenced shortly after the ICC arbitration started. At that point, everybody is thinking in terms of alter ego and succession, because that's what the Pakistan judge has just said. The ICC arbitration, as your Lordships are aware, was begun on the basis of alter ego and succession. And shortly afterwards, by way of reaction, the government picked up the false invitation, the invitation of the Pakistan judge, and recast their case as a government's case. And that was the poor cut-and-paste job that we saw in the 1998 proceedings. For your note, can I point out paragraphs 2 and 14 of the 1998 plaint in the Pakistan proceedings? I can take you to it or just give you the reference. The reference is Bundle E, tab B1, page 13. And that is an application of 2nd of June 98. Paragraphs 2 and 14 were picked up by Mr. Justice Aikins as being significant because they belie the case that Dallah's putting, that somehow this was an admission by the government, because it records, firstly in paragraph 2, that the trust has lapsed because of exercise of paragraph 89 of the Pakistan Constitution. The 4-month period had passed. So they record, firstly, that the trust has gone, and then in paragraph 14 of the plaint, the government states that it records the 1997 proceedings that were brought by the trust, and then it records what the judge said, which is that actually this is a claim that could be brought in the name of the government, because the trust had gone. And the reason I stress those paragraphs is that, again, that's an indication of what the government was intending in 1998. Not that it's now agreed it was a party, but it was taking up this invitation from the judge. Those 1998 proceedings are very significant for Dallah's case, as your lordships will be aware, because they've put their focus on the latter part of the chronology. Accepting they have difficulties with the MOU and the agreement, they say, well, look what happened afterwards through the French test. So the 98 proceedings are important, but they were short-lived. They were only alive for 6 months, which is short in the scheme of Pakistan legal proceedings. They were then withdrawn. In my submission, you can take a fair view as to why they were instituted, because there was a knee-jerk reaction to the ICC arbitration, and because a judge had just told the government that they could actually commence proceedings. They were withdrawn in January 1999, on or about 14th of January. The reference for that, the court order, is Bundle E, tab B10, page 47. On the same day that the 98 proceedings were withdrawn, the third set of proceedings were commenced by the government. These are the 1999 Pakistan proceedings. And that was back on script, because the government at that point brought an application before the Pakistan courts to say that the government of Pakistan had never been a party to the agreement.
So EB10.
E, and then sub B, and then 10. So bundle E is divided into AB. Sorry, I said B. It may be. Let me just quickly double check that.
I said page 47.
Page 47. Forgive me. Let's make sure I've got given you right.
Yeah, it's page 47. It's just illegible page number.
47 is the court order. 47, bottom right, is the court order confirming withdrawal of the 98 proceedings.
Right.
Yeah, okay.
So thereafter, a new application is brought.
I'm so sorry, Mr. Landau, can you give me that reference again?
Yes. It is bundle E.
Bundle E.
Yep. Tab B for Bravo, number 10.
Thank you.
Page 47 of the bundle. So that's the court order 14th of January 99. It's a withdrawal of the 98 proceedings. And then, significantly, on the same day, the next set of proceedings are commenced by the government. And that you find bundle E, tab C1. The easiest place to find it is page 48 of the bundle. And this is the government of Pakistan now bringing a full-scale claim before the Pakistan courts for a declaration that it was never a party to the agreement.
Is this the application under Section 33?
Yes, now Section 33 is a curious provision.
Yes, but just to identify the document.
Yes, it is.
It is. The page numbering is not easy to find.
I'm sorry for that.
But it's the first page in C1.
Yes. I won't go into Section 33, but all the court needs to know, my submission, is that this is a full hearing before the court, an application for a declaration that the government was never a party to the agreement, and that it's not the successor of the trust, and that there's no privity of contract. Now, in my submission, what's relevant here, as was found by Mr. Justice Aikins and the Court of Appeal, is if you, as you have to do through French eyes, look at the full chronology from beginning to end, you've got the 1998 proceedings sandwiched between, it's a short period of time, sandwiched between 97, where it's the trust bringing a claim, and then 99, where the government's saying we're not a party to any of this. If you take a reasonable, fair view of that, you can't take that 6-month period, in my submission, as being an admission by the government that it is a party to the arbitration agreement. If nothing else, one can see reasonably why they acted in that way, because a judge gave them a false lead. But also, through French eyes, the test is, whether it's subjective or objective, are they to be taken as having accepted an arbitration clause? Well, in my submission, starting a court proceeding is a curious way of accepting an arbitration clause. The only other points I need to mention before
That's a slightly separate point. I mean, they were clearly resisting the arbitration clause, but I mean, it's equally clear that they were prepared for one reason or another, and maybe on an entirely false basis historically, to assert that they were parties to an agreement, had been, or had become.
Well, my lord, the difficulty with that is that if one looks at paragraphs 2 and 14 of that plaint of 1998, the basis upon which the government was willing to take that position was succession or alter ego. And those are bases which Dallah has now abandoned.
Well, does it much matter? I mean, if the whole idea of common intention seems to be quite elusive, or it seems to me that obviously, if we're asking ourselves, does this show that at the time when the contract was alive, during the trust life, does it show that the government of Pakistan was a party to the contract? The answer I think you'd give would be no, because of paragraphs 2 and 14, all they're asserting is that they somehow became a party.
Yes.
But if that is the relevant moment, then one might find an intention in that 6-month period.
I mean, if there was a common, I know this is contrary to your case, but if there was a common intention in that 6-month period, so that during that 6-month period, assuming there'd never been a common intention up till then, but in that common, if contrary to your case, on the facts it were held that there was a common intention that the government should be a party to the contract and thus to the arbitration clause, since no line had really been drawn between being a party to the contract and a party to the arbitration agreement, then that would be enough for French law.
Well, it can answer that two ways. Firstly, all of this probably makes no difference, but the main point is no. And the reason for that is this court has not had the benefit of the live testimony on the French test, which Mr. Justice Aikens had.
You can have a variation of a group, can you not? I mean,
the point
have
about,
a fresh agreement.
My Lord, the point about the French test, which is set out most clearly in a decision of the Paris Court of Appeal in a case called ORRI, O-R-R-I, which I will come to later in the context of transnational law, is the French test asks the question, subjectively, did the parties accept the arbitration clause? If a party is declaring in a proceeding, we are by operation of law a successor, in my submission, that is analytically distinct from it intending subjectively to be a party. It may be a successor, but it doesn't want to be one.
Maybe, but that's a question of fact, isn't it?
Exactly, but that's what we're talking about here, is a question of fact. We're talking about applying the French test reasonably to these facts.
Right. But it is a question of fact.
It is a question of fact.
If it did, on the facts,
Yes.
amount to such an
I accept.
acceptance, then it would satisfy the French legal test.
I accept.
So we're all back to the facts, really.
We're back to the facts.
But the substantive point, or the point you're making here, is that everybody has approached the arbitration agreement, including the tribunal, as an autonomous, separate agreement. And so the question to ask is not, were the government of Pakistan accepting that they were at some stage party to the main agreement, the actual contract, but were they actually accepting an obligation to arbitrate? And
Yes.
the one thing that's clear in the 1998 proceedings is that they were denying that, isn't it?
Yes.
I think.
Yes.
Yes, I mean, actually, I mean, the curious thing is that
How do they do
although
that?
they were accepting that they were a party to the main contract, they were also saying, probably erroneously in English common law at any rate, that there had ceased to be any contractual relationship as a result of repudiation.
Yes. I mean, the truth is, my Lord, this does not withstand much scrutiny as a matter of law. It is a cut and paste application which commenced on a false premise at the invitation of a judge at first instance in the previous proceedings. What then happens is that the position becomes a little bit more clear as a matter of logic when they then withdraw this proceeding and start the 1999 proceedings. And what then happens in the 99 proceedings, finally, is Dallah says you can't bring them, you've got no locus standi because you're saying you're not a party to the arbitration. Remember, 99 proceedings are under the Arbitration Act 1940 of Pakistan, Section 33. And Dallah says you've got no right to seek any relief in relation to the arbitration because you are not a party. And the Pakistan court agrees. That's what happened in the 99 proceedings. One thing I should mention along the way, again, we'll leave the facts in a moment because the problem with all of this is one's looking at individual points in a continuum. But at the same time, the court must not lose sight of the fact that Dallah the government of Pakistan is making its position crystal clear in the ICC arbitration itself that it's not a party, while the 1998 proceedings are on foot. So one couldn't look at the 1998 proceedings without also taking into account what they were saying to the alleged tribunal.
The way the Court of Appeal put it in paragraph 41 is that the French law didn't require the judge to engage in a technical exercise in which the government could be impaled on an apparent admission, he says. It required him to ascertain the common intention of the parties on the basis of the evidence as a whole, taken fairly as a whole, it goes on to say. So that's really your point, is that you don't stop at what might be taken to be an admission, because as history moves on, and there's the 1999...
That's my only point, my lord.
Yes. So it's really dealt with both by the judge and by the Court of Appeal.
It is. That's my only point in stressing the rest of the Pakistan proceedings, is to urge this court not to upset what the Court of Appeal has found, which is that there's no reason to upset that the French test looks at a continuum. Dallah's not criticising the application of the French test in this case, but they are now seeking to impale the government on one admission in isolation.
Yeah.
But where is the French test best summarised in the Court of Appeal or elsewhere?
It's in Mr. Justice Aiken's. You'll have the paragraphs already, I believe, in Mr. Justice Aiken's judgment, about 85 and 86, around that
Yes,
part. But the judgment I've referred to, where the best statement of the case, statement of the test. Your Lordships will be aware that the way that the French courts work is with a jurisprudence constante. So you get a paragraph at the beginning of the French judgment which summarises the current status of the test, which they're applying. The best articulation is in a case called Ori, which was referred to before the judge. And I'm just see if I can find the reference. Can you give me the reference to that? It's in bundle B1. B1 tab 22.
E1.
B1, B for Bravo 1, tab 22. It's a French decision, Court of Appeal of Paris, 11th of January 1990, and that was a test that I put to Monsieur de Reims in cross-examination for him to confirm that that was the operative test. It may be set out in my written case.
I must say, we have decided to number the bundles Part 2B and then Part 2B1. Is there a Part 2B2?
There isn't, but it's
very
organic.
confusing.
It's organic. I said organic because what happened was the bundles grew up to this position before the Court of Appeal, and there was then a decision to keep them as they are.
Oh, I see. So B1 is what, just for us?
For some reason, whoever's in charge of the bundles doesn't seem to put the bundle numbers on the inside.
No.
Which seems to me to be a very serious offence.
So some of us are hoping for an answer on bundling.
What is Part 1, as a matter of interest? Is that an
That's
appendix?
the Supreme Court. Is it
Appendix.
the Part 1 Supreme Court numbering?
That's the appendix?
Yes.
Yes, I see. Right.
We're now looking at, I have a document which says Appeal Bundle, French authorities with translations, B1.
That's the one.
Is that the one? What tab?
Tab 22.
22. Oh.
We have the translation.
It's in paragraph 88 of Mr. Justice Aiken's, the slightly different translation.
Yes. The point which I made to the Court of Appeal, which I believe is reflected in the judgment, is that this exercise at the appellate stage is, of course, a little bit difficult because Mr. Justice Aiken summarised lengthy and detailed oral expert evidence, and he himself took the advantage of the moment of questioning the experts himself. So he had a full understanding of this test and applied it to the facts. It's difficult for the Court of Appeal, and if I may say for this court, to repeat that exercise without the benefit of the live witnesses. But the test which I put to Dallah as the best encapsulation is the first paragraph in italics on page 241.
You're asking us to look at B1.
I was only because I was asked to identify.
Rather than the version that the judge used.
It may be. It's probably better to go back to the original that he was summarising.
All right. Yes.
And that's at page 241 of bundle B1, the Appeal Court of Paris.
As I see, this is a different translation from that he uses in paragraph 88.
Yes.
241.
Yeah.
It's French.
If your Lordships have it, it's the fifth paragraph on that page, the first one in italics, and that's where you get the statement of the the French test, which is then repeated and repeated through all the cases. It begins according to the customary practices of international trade.
Yes.
The arbitration clause inserted into an international contract has its own validity and effectiveness, which require that its application be extended to the parties directly involved in the execution of the contract and to any disputes that may arise therefrom, provided it is established that the situation and activities of those parties allow it to be presumed that they accepted, that's the key word, they accepted the arbitration clause, of whose existence and scope they were aware, even though they were not signatories of the contract stipulating it. When I cross-examined Maître Darras at first instance, I elaborated on that point about acceptance of the arbitration clause. It's not just, well, we are parties to the agreement. It's more specific than that. Now, I'm giving you...
It actually says, in the French, it says the contractual situation and activities.
But, Lords, again, to bring us back to, if I may, the position where we are at the moment, we cannot recreate before this court, I can't recreate the full exposition on French law that happened before Mr. Justice Aikens. For your purposes, you have the summary, certainly, of the judge. You have the Court of Appeal's slight refinement on what Mr. Justice Aikens had summarised by inserting an issue of communication between the parties. And there's not much more that one can do at this stage unless you want me to go through the ins and outs of the French test, which...
I mean, basically, and this hasn't been challenged as a finding of French law.
No.
Paragraph 122, he may say it elsewhere, but in paragraph 122, he says, the process under French law principles requires me to consider the whole chronology, not to take a snapshot at any particular date, which is your...
That's my point. That's my point. And I think if I may ask the court to wind back to the position where we are, if the French test is not being challenged in front of your lordships, the issue really is the only point actually to look at the facts now is Dallah's thesis that the tribunal was sustainable and as good as Aikens, and somehow you should therefore prefer the tribunal. And what I've put together in my written case and my submissions is my major criticism of the tribunal as to why they didn't do the right thing and why it's not sustainable. And that's been elaborated in my written case, and it was accepted by Mr. Justice Aikens and by the Court of Appeal. So the only issue now for the court is really the test of review, of the exercise that the court was to conduct.
I see that the trial judge at paragraph 94 deals with the point about the succession argument, which we're not concerned with now. This is at page 356, I think in D in the appendix. And what he's saying is that the experts were asked to consider whether the mere fact that you were a successor makes you bound by the agreement according to the French test. And the answer is no. There must be more to demonstrate actual consent to being bound. That's the acceptance point.
It is. And I should just say, in my written case for this court, I have set out in some detail the test from paragraph 29, page 14 of my written case. I've set out excerpts from the judgment and the evidence about the nature of this test. What it includes was, of course, the statement, paragraph 39 of my written case of Monsieur Darras, that anything less than a conscious and deliberate act of the government would not be sufficient. Conscious and deliberate act, and there's a transcript reference.
That was paragraph...
Paragraph 39 of my written case, page 18, internal page 18.
But you can infer that, can't you, from the objective indicia?
Yes, of course.
And you can have a variation. I mean, to my mind, one can take this continuum point too far. I mean, I simply don't believe that French law doesn't have an arrangement whereby you can have a change in the course of the continuum.
Of course you can.
They obviously recognise that they could have formed an intention halfway through, which they didn't have to begin with.
Absolutely.
Of course, you'd have to be able to find that, and of course, the other side would also have to agree it before you had an agreement.
Absolutely.
But the critical point, to my mind, really, is in paragraph 122, is the judge's point. He says, he isn't so much saying, well, if you look at the original MOU, so if you look at the original agreement, that they obviously weren't a party, and that's it. What he's saying is, when you look at the whole thing, including what happened after that, and critically, you have to look at what happened not only in the 1998 proceedings, but what happened after the 1998 proceedings in 1999. So, but I think one can overstate the rigidity of the French text,
No, I didn't
or even the looseness of it.
Well, I certainly didn't mean to do that. I didn't mean to say it was rigid, but if I may say, your Lordship's completely summarised the point to make. The continuum is simply, you look at everything reasonably. And in my submission, what the tribunal did was they looked at 1998, but they didn't look at the 97 proceedings, and they didn't look at the 99 proceedings.
Well, I have great difficulty in working out what the tribunal really decided on this point. But one thing is clear, it didn't apply anything resembling the French test.
No, it didn't. It didn't. And when I come lastly to transnational law, this is a point that needs to be clarified, because I must say there's a bit of sensitivity in the outside world about this. But they did not. They did not apply the French law test as it was expounded before Mr. Justice Aikens.
What it seems to me they did is, while rejecting the alter ego theory, in fact, they
applied it.
They really applied it.
And the reason they applied it is because they applied a wider rules of law, open-ended, transnational approach, which is different from French law, where you can look at many different things, whether it's lex mercatoria or unitoire. They applied a bit of Dow Chemical group of companies, a bit of alter ego, a bit of common intention, a bit of good faith.
Well, if there's a principle at all, it's a principle that if a government is intimately involved in the negotiation, implementation and termination of a contract, that makes it a part.
And that's Dow Chemical. And Dow Chemical is an ICC arbitral decision. It's not part of French law.
I don't think they did reject, even purportedly, the alter ego principle. As I read it in paragraph 4 now, having reread it, that's page 413.
Sorry, paragraph what?
4 of the arbitration award.
I'm looking at a different version. What page? The internal
page 25.
Internal page 25. I think that those first 2 paragraphs are saying we can't accept the alter ego principle by looking at the rules and regulations without more. Because the first paragraph is dealing, the rules and regulations on their face create a separate legal entity, and the rules relating to the Board of Trustees and the control is not in itself sufficiently pertinent to impair the distinct legal personality. So that's the starting point. But then they go on and examine a huge range of other activities. As I see it in paragraph 12.1, page 34, internal numbering, the first paragraph actually is an acceptance of the alter ego principle.
It is.
Categorically.
It is.
And that is reiterated in the penultimate paragraph of this, on page 35, admittedly only through the eyes of the chairman, who's saying he's comforted by other things to think it's the alter ego.
Yeah. Yes.
Yeah. So, I mean, I think that rationale does seem to be alter ego.
It is, but it's a mixture. I mean, in fairness to my learned friend, there are points here where they are suggesting common intention. But
but I think they're sort of getting that.
They're getting it with an amalgam with alter ego. My Lord,
they're getting alter ego from elements of common intention.
Exactly.
It seems to me, yes.
It's a complete medley of principles which may be open to them as a matter of transnational law, but not French law.
So there's no sign is sort of applying the test of acceptance.
No. Not as it was articulated before the trial judge. The passage I read to you from the Ori judgment is not the same as what they've done here. That's one way of looking at this. That's why I wanted you to see that encapsulation of the test, because that has clear criteria in it, which do not appear to be applied. If I may just pick up...
Can you just help me a moment? You said someone was sensitive about something. Is it the authors of books on transnational law who are sensitive?
Well, it's actually part of the French nation.
The French nation?
Yes, I'm going to come to this, if I may, when I get to transnational law. But in one of the articles that my learned friend cited at the beginning of her presentation from the Cahiers de l'Arbitrage, which has come out recently, there are 2 articles that came out on the Court of Appeal judgment. There is a misconception that the English court is being overly English and it is putting forward a conception of French law that excludes transnational law, whereas French lawyers believe that their law includes transnational law elements. Now, when I come to this, I'm going to explain, it's a very easy answer to that, but if you would allow me to park that, to deal with it at that point. So where I think their sensitivity is that the outside world needs to understand that the Court of Appeal and Mr. Justice Aikens were doing exactly the same as the French court would have done. They were not being anti-French or anti-transnational law, but it all has to be seen through the prism of French law. I'll come to that if I may.
I mean, to be fair to Ms. Heilbronn's argument, paragraph 12.1 does seem to be I wrote shall and then alter ego against both the whole of paragraph 12.1. Paragraph 12.2, however, does seem to be a sort of common intention point.
Yes. I have to be, in fairness, there are common intention points in this, but what's difficult about the award in my submission is that the tribunal said that it was an accumulation of facts. So for them, the individual points in time were not enough. My learned friend relies upon the letter of termination and the latter parts of the chronology, but that wasn't enough for the tribunal. They said you had to read it all together. But what did they read together? They read together a misconception of the previous facts plus alter ego elements, which have been abandoned. So if you strip away the parts of the tribunal's award that really are not admissible anymore or permissible, you're not left with enough for the result. And if you put on top of that Lord Mustill's hesitation, he says it's close to the line, this confusion about good faith, which the chairman, Mr. Mahmasani, uses to bolster, to comfort his analysis, this is an award which actually, upon scrutiny, taking away alter ego and succession is not sustainable.
Going back to page 422, I'm looking at paragraph 13, just to see how this all fits in. There is a reference there to looking at the elements globally as a whole. So, to that extent, the French approach is being adopted,
yes,
is it?
There is a coincidence of features between the French test and what the tribunal did, for sure. The problem is it's not the same. They do things which the French court would do, but it's not the same test they're applying.
What's also unclear is which bits are just Dr. Mahmasani and which bits are the others. Yeah. I mean, for example, the second paragraph of paragraph 13 seems to be Dr. Mahmasani. And then paragraph 14, that's all Dr. Mahmasani, is it?
Yes, paragraph 14 seems to be, because you then get to the bottom of the following page,
yes, and
you have Dr. Shah and Lord Mustill's view.
Well, it's quite clear the contrast between the top of page 35 and the bottom, isn't it? Because we've got Dr. Mahmasani, first three paragraphs, on page 35, internal page numbering. And then we've got Dr. Shah and Lord Mustill not convinced by this, although they say they're reassured.
And what's also curious, my lords, if I may refer you back to page 20, internal page 20 of the award, paragraph 3, when the tribunal articulates the principles that they're going to apply, they talk about, in paragraph 3, rules of law. They say judicial as well as arbitral case law. Now, arbitral case law is a shorthand for Dow Chemical, in my submission. The Dow Chemical, I don't know if your lordships are familiar with it, but it is an ICC arbitral award that has given rise to what's been called arbitral case law on something called the groups of company doctrine, which has come before the English courts occasionally and been roundly rejected. But arbitral case law is not French law. That's previous decisions of arbitrators. They say here, arbitral case law now clearly recognise that as a result of the principle of autonomy, the rules of law applicable to an arbitration agreement may differ. Then it is a reference to Dallah, and then it says 3 lines on the bottom, may consist of transnational general principles, which the arbitrators would consider to meet the fundamental requirements of justice. Then it says, Dr. Justice Shah and Lord Mustill would not endorse without reservation the concept of a transnational procedural law independent of all national laws. They need not, however, pursue this, since it makes no difference to the result. Now, in my submission, that's difficult to understand. Why does it make no difference to the result?
Well, hasn't it got to be read with the paragraph on the next page, under paragraph 2, and it seems to suggest that they're reserving the position on whether there's a transnational procedural law.
But I'm not sure what the distinction is here between a transnational procedural law and a transnational substantive law. The only thing they appear to be applying are transnational principles to answer the question, who is a party to the agreement?
Well, presumably they're not considering that to be part of procedural law.
But what is the procedural law that they're referring to, which is my question? If it's not that, because the only question that they're addressing is who's a party to the agreement.
It's quite interesting to look back at paragraph 1, the third paragraph within it, to see what the argument was. The claimant was contending the law applicable is Saudi Arabian law.
Yes.
Defendant submits the agreement is governed by the laws of Pakistan.
Yes.
So
And
that was
because
the contest.
That was the contest. And that's why they say our answer is no national law.
It's page 407. It's actually...
That's the starting point for all this. They've got a competition between Saudi Arabian law and Pakistan law. They resolve it in a very classical French way of resolving it, which is to elevate everything above the level of nations to a transnational legal order, independent of all nations. And that, when we get to it later, is the starting point to make a distinction between French law and transnational law. Where this gets complicated is I have to, with your permission, explain a little bit more about the content of French law, because it does have so-called transnational elements, and that's where the sensitivity is.
So is that what they're saying in paragraph 4 on page 20?
Yes.
Where they believe they don't have to determine whether it is Saudi Arabian or Pakistani in view of the autonomy of the arbitration agreement. And it doesn't have to be assessed with reference to either.
Yes.
Then they come on to
the
international character of the thing.
The point here...
This only applies to the arbitration agreement.
Yes.
Yes. All these doctrines, do they not apply to the substantive provisions?
No. The substantive agreement, according to the tribunal, was governed by Saudi Arabian law.
But how do they arrive at that? I mean, why do you apply different criteria to these different questions?
Because the French, for arbitrators sitting in France, they are entitled by conflicts of law to treat the arbitration agreement as governed by transnational principles because of the nature of the arbitration agreement. It is an agreement which has validity by reference to a transnational legal order, different from other contracts. That's a conception of arbitration that we do not have in England, but they do have in some civil law countries. So there are French rules which allow them to do that for the arbitration clause.
But the first thing they're saying is that, contrary to what the parties were apparently basing themselves on, you distinguish between the arbitration clause and the main agreement.
Yes.
And then the second thing is it that you distinguish between the law governing the arbitration clause and the procedural law which will govern the arbitration. And
that's for sure.
And it's the latter which Lord Mustill and Dr. Shah question whether can be governed by transnational law. The former they seem to accept can be.
I imagine that's right, but of course the first partial award is only concerned with the question who is a party to the arbitration agreement. So
presumably in some later award, though, they deal with what the relevant procedural law is.
They deal with in the second partial award. They deal with the substantive governing law of the main contract, which they find is Saudi Arabian law.
And when do they decide what procedural law they're going
I'm
to
not sure that I'll be corrected. I'm not sure there's an express finding on that, but I suspect that at the moment I don't recall a finding on that on the actual.
So they all seem to be agreed that the arbitration agreement, or the question whether there is an arbitration agreement, is detached from any national law and is subject to some transnational law.
And that embraces the very question whether the defendant is a party to the agreement and to the arbitration.
And that's because of the ICC clause, is it? Or is it the fact that the arbitration is taking place in France? If it were an ICC arbitration taking place in London...
This doesn't flow from the ICC rules. There's nothing in the ICC rules.
It flows from the fact that the arbitration is physically taking place in France,
yes.
is it?
Yes.
And doesn't it flow, I mean, logically, shouldn't it flow from the fact that it's an international arbitration? I mean, could it really be different according to the seat?
Well, forgive me, the point we're on is what? I mean, what is different, can I ask?
Well, what is it that decides whether this can be subject to
a transnational...
whether the existence of an arbitration clause is subject to transnational law?
Right. The starting point, of course, is the ICC rules and French arbitration law, being the law of the sea. That's the framework for the tribunal to decide on what law governs.
Plus, I think they're saying without any reference in such agreement to any national law.
Well, that's the next stage, which is how they're applying their finding, their analysis. Putting aside the award for now,
Right.
you have got an ICC arbitration clause with a Paris seat.
Yes.
You get from that French arbitration law, the equivalent of our 96 Act, which sets up the structure for the arbitration, the procedure, plus the ICC rules by agreement. So you read those two documents together. That is the governing structure. Article 6.4 of the ICC rules gives a choice of law, sets up the choice of law principles for the ICC arbitrators. They have flexibility under the ICC rules to apply rules of law as well as law. And
Now,
French...
there's been a rule of law in the law.
Sorry? What's the difference?
I didn't understand.
There's a big difference between the expression law and rules of law. They're both terms of art. Rules of law is not limited to one national legal order.
These are terms of art in what context?
In common usage in international arbitration. I'll show you these references later. They come up because it's relevant in understanding your convention. There's a debate between law and rules of law in all on-trial documents, a debate that featured in the model law, it featured in the 1996 Act. So across all these different systems, law is treated as being different from rules of law.
Well, just give me an example of law as opposed to a rule of law.
Law would be English law. Rule of law might be the International Sale of Goods Convention. It's not one national legal system. It's just an international legal principle. This is all set out in the written case by reference to the model law and the commentaries on that. This whole debate happened with the 1996 Act. Should we expand our definition of law to rules of law and allow arbitrators to apply, if I may call it soft law, transnational principles? And we've decided not to.
Are the ICC terms of reference in the...
The ICC rules are.
No, the terms of
reference. Yes, I think in bundle D.
Did they establish the seat or simply
Yes.
the place of arbitration?
Let's see. Yes, tab 6 of bundle D. So the place of arbitration in this case was fixed by the ICC court, not by agreement, as France. That you get from page 23 of the terms of reference.
It was fixed by the ICC court.
Yes.
Sorry,
Yes. Tab 6,
Bundle D.
page 23 is where you find that.
I mean, the fact that it was fixed by the ICC seems to me, on the face of it, to make it even more artificial to suppose that this is something which French law determines.
Yes, I mean, it's fixed by the ICC in circumstances where the government is saying, we never agreed to ICC.
So where do we find this? Terms of reference?
Terms of reference, place of the arbitration.
Yeah.
That's what we would call the seat, to what the statute would call
Yeah,
it.
the seat, exactly.
And we find the place of Paris fixed. Oh, yes, I see. Meetings of the
Yes, I'm being helped here because
Paris shall remain the place of arbitration.
page 11 of the terms of reference is where the tribunal set up the structure in terms of governing law.
Where are they?
That is bundle page 30.
Page 13.
30. 30. Bundle page 30.
That's simply declaratory of the ICC rules.
The agreement does not contain any provision as to the rules of law to be applied to the merits. Therefore, the arbitral tribunal shall apply the rules of law which it determines to be appropriate in accordance with Article 17. In fact, I gave you a misreference before the ICC rules.
What does the clause say?
17?
No, what does the clause in the contract say? In the agreement?
just settled by arbitration held under the rules, the ICC rules.
Yes.
It does say Paris. I'm being corrected. That's right. It's clause 23 of the agreement. For your reference, bundle C, page 199.
That isn't fixing the place of arbitration. That's just simply describing the ICC, isn't it?
Well, it says shall be settled by arbitration held under the rules of the conciliation and arbitration of the International Chamber of Commerce, Paris, by 3 arbitrators. So, obviously, one can imagine the debate: is that the location of the institution, or is it the legal seat of the proposed arbitration? And it seems like it may well be identifying the ICC as the body in Paris. In any event, the tribunal have found. Well, the ICC have fixed Paris. One doesn't know whether that's because they interpret the agreement that way, but that's what they've done. Going back to the terms of reference, page 30 of bundle D, I was taking you to, which are the other particulars that the alleged tribunal set out. Applicable law, they say there's no choice, so they will look to Article 17.
And where are the rules?
Of the rules. The rules are in Authorities Bundle 1, tab 10.
Would you like us to look at that, Joe?
Now, this is about the merits, not the procedure. Article 17 of the ICC rules.
Well, Article 15 deals with procedure then, but we're looking at 17, are we?
17, only because I'm pointing you there, because that's what the tribunal first referred to. But that's applicable law to the merits. Then the next heading in the terms of reference is procedural rules. This is the procedure of the arbitration.
Yes.
And here they say the arbitration proceedings shall be conducted in accordance with the ICC rules, and where such rules are silent, with any rules made by the tribunal, agreed by the tribunal. So that then must be in accordance with French arbitration law, being the law of the seat that they're sitting in. So where we get to at this point is...
So are there any ICC rules, procedural rules that are around?
Well, only what's in the ICC. The ICC is a procedural set of rules.
But Article 15 says rules governing proceedings,
Yes.
but it's not very specific.
No, because the way that this works is the only restriction will be the mandatory rules of the seat. The tribunal can do what it is allowed, whatever it wants to do, constrained only by the mandatory rules.
Well, under the ICC rules?
No, the mandatory rules of France. They can do whatever they want under the ICC rules.
Yes, that's my point.
Yes.
I mean, under the ICC rules would govern, subject to the mandatory rules of France.
Exactly right. Exactly right. Same in England. If you had ICC London, same.
You're not saying that the question of who's bound by an arbitration, whether someone's bound by an arbitration agreement, is a question of procedure?
No.
Well, why are we getting involved in...
We're getting involved because I'm
procedure
asking...
at all?
Well, I think I may be now answering questions...
It's probably my fault.
No.
That's my
It's my fault. Can I wind back at this point? Just to, in fact, and with your permission...
It's really relevant to the true construction of the arbitration reasons, I suppose, to see
where
what
we
it
got
was
to
they
this.
thought they
We
were
got
up
to this because we were looking at trying to understand the tribunal's award.
Yeah.
Can I, with your permission, can I just wind back to that point? Where we end up is that, in my submission, what the tribunal has done is they have applied transnational rules, not French law, and they have conducted an exercise. This is the important point. They've conducted an exercise which is not open to a court under Article 5 of the New York Convention. It may be open to the tribunal sitting in France as arbitrators, but it is not open under the conflict of law rules in Article 5.1a of the New York Convention, and equally Section 103.2 of the 1996 Act. That's the point to take away from this. Now, with your
would that
permission-
be true in France? But if they tried to enforce in France, which happened to be the seat of the arbitration, they would have to apply Article 5.1a, would they?
No, because 5.1a is only for foreign awards. They would have to apply the French Civil Procedure Code to enforce a domestic award. If 518 is only for foreign awards, incoming awards under the New York
Yes,
Convention.
I see.
So the equivalent in England is if you have a London seat, somebody can come to the commercial court to enforce, not New York Convention, that would be section 66 of the 1996 Act. It's a domestic process.
Yeah.
As it happens, can I make this point by way of verbal footnote only? As it happens, if you go to France with a French award, they will do exactly the same thing as they do under the New York Convention. They will apply French law to this question of initial consent. And the case on that is SPP Pyramids. That was a French enforcement. That's a very famous case we keep mentioning. It's an instance of the enforcement of a French award in France, applying French law, where the tribunal applied a very similar set of principles as this tribunal's done to attach it to make a government a party that was not a signatory. And when the French court reviewed it at enforcement stage, they applied French law.
That was a French award.
It was a French award.
Yes.
They applied French law and the Ori test that I've shown you. And it's the same, the evidence has been it's the same thing they would do under the New York Convention. And that was a footnote, just to explain what would happen in France. So,
And would they apply, if your clients had applied to set aside the award in France, they would apply the same test?
yes, the same test.
So they'd apply the same test if your clients applied to set aside the test, or indeed if they wanted to, if the other side tried to
Same
enforce
test.
the award in France.
Same test.
And here, what if if a tribunal, an ICC tribunal sitting in London applied transnational rules, what would happen here?
The question would be it would be tested by Section 46 of the English Arbitration Act. Section 46 of the English Arbitration Act sets out the rules which a tribunal is allowed to apply to matters of substance. Section 46 says, and of course this is instead of the Rome Convention, Section 46 says,
Where is it?
it is in Authorities Bundle 1.
Oh, it's two. It's got down
Yeah.
to, yeah. We're contemplating they applied transnational law to what
Yeah,
issue?
to the issue of who is a party.
Yes, that's it.
So assume this was a London arbitration, ICC arbitration. (46)(1), if your lordships have that, the arbitral tribunal shall decide the dispute. So this is a mandatory provision. A, in accordance with the law chosen by the parties as applicable to the substance of the dispute. Now that says law, not rules of law. That was a conscious decision at the time that this was drafted. I'm going to take your lordship shortly
This
to
is
that.
circular because the issue is who is a party. So wouldn't they apply the putative?
The putative, yes,
proper
of course,
law?
of course.
Yes.
Putative, it has to be in that
So I
situation.
mean, it's not really Section 46. It's by analogy with Section 46. You apply the law which, in a rather circular way, would apply if these were parties.
Well, it's still got to be Section 46. The issue before the alleged tribunal is Party A a party? That is a question of, that's a substantial question. They will have to apply a law.
That actually isn't the issue before them because, that hasn't been submitted by any agreement to them. It's just as if they're deciding whether there's an arbitration clause at all.
Yes.
You have to find some law.
Yeah, but this is applying, it's described as applying to the substance of the dispute.
Yes.
So here, if they'd chosen Saudi law
Yes.
to apply to the substance, that wouldn't affect necessarily the governing law of the arbitration agreement. So what happens under the Act if they have chosen the law to govern the substance of the agreement, or there is a choice of law in the agreement as there was here, but there is a dispute as to whether a party is a party to the arbitration agreement, and then the arbitrators apply transnational rules of law to determine
The
that
English
question.
court would not do the same. The English court would apply just law to that. In fact, I'm thinking on my feet, I'm afraid, my lords.
Are we still under Section 46?
No, at this point we wouldn't be. We wouldn't be.
No.
My Lord Lord Collins is absolutely right. Because actually, Section 46 is the equivalent of Article 28 of the model law, which is, if your lordship will allow me to backtrack a few steps, That is the substance of the dispute as referred. Not so. We're distinguishing here between the law governing the substantive contract and the law governing the arbitration agreement. Law governing arbitration agreement would not be within Section 46.
But just assume this case had happened in
If
London.
this case had happened in London, in my submission, the English court would restrict itself to English law. As the law, it would ask itself, first of all, what law governs the arbitration agreement? That would be the first question of the analysis, because it's the law governing the arbitration agreement that will dictate who are the parties, like any contract, putative law. That's step one. Step two, you apply a conflicts principle to establish what law governs the arbitration agreement. The conflicts rule in England is, after the Court of Appeal in C versus D, unless there's any express indication, it will be the law of the seat as the closest connecting factor. The only other competing factor might be the law governing the substantive contract in which the arbitration clause is placed. So can I just to summarise my point, because I was on a false track before. Question is, who's party to the arbitration agreement? Answer depends on the law governing the arbitration agreement. What law governs the arbitration agreement? As a matter of English conflicts, it will be either the law most closely connected, which will either be the law of the putative seat, or if there's some other reason, you would look to the law governing the substantive contract. After C versus D, the emphasis in England now is the law of the seat, which is a new thing. So the English court would then say, if the putative seat is England...
That was a case where the law of Bermuda or somewhere was the...
Yeah, and it was a case that then involved...
they agreed the law of New York as
exactly. That's the case.
As governing the substance.
And C versus D comes after a line of cases in the English courts where traditionally the English court would actually look to the law governing the main contract. Sumitomo, Mr. Justice Potter as he then was, 1994, and a line of cases before that. In the English courts used to say the factor with the closest connection would be the law governing the main contract, because this is just a clause in the contract. After C versus D...
Yeah, but the whole point of C versus D was to have an arbitration in Bermuda and not to be governed by...
Exactly. And this follows actually a sort of international trend, which is actually the most important connecting factor is often the choice of seat.
So if this case had arisen in London,
yes,
then the government would have applied under Section 67 to set aside the interim
and
law.
the English court, after the analysis I've summarised, would apply English law.
As the law of the seat?
As the law governing the arbitration agreement, arrived at, by closest connection, English seat.
And how would it reach that conclusion? Is that because of terms of reference or what?
The conclusion that English law governs?
Yes.
No, by
simply because it's the seat, is it?
Applying an English conflicts of law rule, as I enunciated in C versus D.
Where is C or D? We got it.
We have.
I mean, it may be quite a...
It's tab 43.
...useful rule, but isn't the law of the seat a rather ephemeral thing? Sometimes you can...
Yes. This is not a hard and fast rule. No. You are looking for the law with the closest connection to the arbitration agreement. You will have cases it's slide 43. You'll have cases where the seat has been expressly set out in the clause. You will have other cases where the seat has been fixed by an institution.
Yeah.
So there may be situations where the seat is not a powerful factor.
Right.
But then you look for other factors.
Yeah.
Yeah, paragraph 26, thank you very much. Paragraph 26 of the judgment. It's got a marginal line on it. It's which I won't read it out, but it's a reference to Black Clawson, and then it says that I'll read out just this bit. The reason is the agreement to arbitrate will normally have a closer and more real connection with the place where the parties have chosen to arbitrate than the place of the law of the underlying contract. In cases where the parties have deliberately chosen to arbitrate in one place, disputes which have arisen under a contract governed by the law of another place. So that is a summary of where the courts have got to. Again, not a hard and fast rule, There will be times where you can't look at the seat because it's not been chosen by the parties or there are other factors.
But this is by reference to Channel Tunnel,
Yes.
which is actually dealing with the law governing the conduct of the arbitration, which is the procedural law, which is a different thing from the law governing the question of whether there is an arbitration agreement.
No, this is about the law governing the arbitration agreement.
The reasoning seems to transpose the statement from one context to the other.
Well,
There's a very elaborate discussion in Black Clawson, isn't there, of the different levels?
Black Clawson, Justice Mustle as he then was, identified, I think, 6, possibly in his mind 12 different laws that might govern an arbitration. And that was because in Black Clawson, he came up with the concept of double separability, which was, anyway, I'm not sure we need to get to that, but many different elements in the process that might be governed by a different law. For our purposes, my lords, the only reason we're talking about this is the question was raised, what if this was in England?
Yeah.
If this was in England, the English court would have to find out first what law governs the arbitration agreement. It will apply English conflicts rules. Now, this debate about C&D is just an elaboration of what those rules might be.
Yeah, well, I see that.
So whatever those rules are, and we can spend time on C versus D, but whatever those rules are, the English court will do that exercise, and it will come to a law. And in my submission, most likely it will be English law in this case. Whatever. That's what the English court will do.
But in France?
In France, they will apply a different process, and that I can now explain.
But the English court could come to transnational principles, could they?
Not unless...
If they applied the law of the seat, and the law of the seat was, say, France, which itself applied transnational principles.
Well, that gets into a very complicated point at that point. That would be applying not the law of the place of arbitration, its substantive law, but that would be include some sort of renvoi, presumably, where you would say, well, we'll do what they would do in France, and in France they would do something else. But I'm not sure we need to get into this complexity.
No, I agree with that.
It does depend very much on what one's talking about. I remember very well Whitworth, Miller against Whitworth,
Yes.
where the arbitration agreement was with reference to the law of England.
Yes.
That the arbitration was conducted in Scotland.
Yes.
And
That's right.
ultimately it was held that Scots law prevailed on procedural matters at least.
Well, but in that case, my lord, as in the Union of India case, which Lord Saville sat on at first instance, you are in a different issue of debating what actually is the seat.
Yes, indeed.
And in Union of India, which is the same as the Wentworth case,
Yes.
the question is actually between seat and venue.
Yes.
Because if you apply the procedural law of Scotland, Scotland's the legal seat, even if it's taking place in England.
Well, you can agree a seat in country A, but actually have the arbitration in country B.
Of course, common practice. Some of us make a living on this.
Just help me on one point which brings us back to the award. In paragraph 3 on page 20, there is a reference to a French Court of Cassation decision saying rules needn't be linked to a particular
Yes.
national law. Have we got that somewhere?
We have got that. That is Dallah.
That's Dallah, and that's reference.
Dallah is in bundle B1, flag 6. Thank you very much. Flag 6.
Thank you, I see that. Right.
Lord, at this point, can I change my proposed running order?
How are we getting on?
We're doing well, but we're doing it in a different order.
I'm sorry?
I said we're doing well, but in a different order.
That's encouraging.
Can I, my lords, at this point, the most efficient thing for me to do, with your permission, is to change my proposed course, which I gave at the beginning, and close off transnational law. I was going to deal with it last, but we've dealt with half of it, so I might as well complete it now.
Yes. Very well.
If that's permissible.
Well, I think we can go ahead that way. Yes, let's.
Because the issue we're on now comes to what does it mean in Article 5.1a when it says the law of the country where the arbitration award was made, or the seat. That's what I need to complete on this point.
All right.
And then after that, the only thing left for me to do, I say only, is the nature of the court's examination.
Yes. Right.
I mean, this may not arise, but if one had a situation where the English court was required to apply or evaluate transnational law, is there any way in which one could do that?
Yes, for the English court?
By definition, it's not law.
No, this is, well, it's always referred to as Lord Diplock's dicta in Amin Rashid, as interpreted most recently by David Richards, QC, sitting as a deputy in the Musawi case, Musawi. That is mentioned in my written case, and it's in the materials. That was the Masawi case, which was about 2 or 3 years ago, was a decision involving the application of Sharia law. Sharia law is not a law as through English eyes. It's a set of principles. It will come under the rubric rules of law, but not law. And citing Diplock in Amin Rashid, David Richards QC concluded that the English court cannot apply transnational principles, transnational rules, absent an agreement. It can do so if that is the express agreement of the parties. I'm now making a submission to, as with all my other points, but in particular on this, to a bench that comprises people who will correct me on these points. I hope that is the position at the moment.
Once you've got an agreement, you've got a contract.
Then you've got a contract.
Yes.
Then you can do that. And of course, we all know famous oil concession contracts that mention national laws plus international principles insofar as they differ. There are many soft law options, but they're all by agreement. Yeah. That is the same policy that is in Section 46 of the Arbitration Act, which I showed you before. Section 46 says the law, but if the parties agree, you can agree to other things like lex mercatoria, unidoir principles, ex aequo et bono, amiable composition, all these other soft law options. Absent express agreement, the courts will apply the law of a nation state.
Is there any material in the bundles of transnational rules being applied as they were in this case to question whether someone is bound by an arbitration agreement?
No, the closest that we have, and we have a lot of it, is the French law conception, which I'm coming to now, of transnational law. Okay, this sounds convoluted, but I'm going to endeavour to make this clear. That's all. I mean, in terms of courts. Well, yeah, I mean, Ms. Argenou was mentioning Dow Chemical, but this is not a court decision. That's a tribunal decision. For court decisions, the answer is no.
But does it come to this? As far as we can see, there is no express agreement in this case that transnational law should be applied.
Correct.
In fact, each side were arguing from a different position about
Correct.
a different system of law. So that's a point that's
Yes.
part of your argument.
Yes. Now, if things sounded complex, they are just about to get more complex, if I may say, because I now need to deal with French law. What is French law? And why is it different from, how does it differ from transnational law? You will recall that the tribunal mentioned the Dallah case, which my Lord Mance has just referred to. And it did so on the basis that, as a matter of French law, you do not have to apply a national law to an arbitration agreement.
The rules,
Yeah.
they say, needn't be linked to a particular national law.
Exactly. The rules meaning the way in which you interpret, construe an arbitration agreement do not need to be tied to a national law.
Yes. So it's quite clear they're talking about principles.
Yes. There is a key distinction here between three categories. Number one, French law. That is the law that will be applied by French courts, absent any other agreement. Number two, the conflicts rules that apply to arbitrators sitting in France. What are they allowed to do? Number three, general transnational law that arbitrators may be able to apply sitting in France by virtue of number two, the conflicts rules. That's the very important distinction in order to understand this area. So the first category is French law as applied by French courts. Categories 2 and 3 is about French arbitrators or arbitrators sitting in France. we shouldn't be concerned with 2 and 3 because for your purposes, you've got to apply French law under Article 5(1)A of the New York Convention. You'll recall, I don't know whether you need to turn that up again, but that's a uniform conflicts rule in the Convention. Maybe it's worth just starting from that point again. The Authorities Bundle 1, New York Convention, tab 12. This, of course, is the same wording in the 1996 Act.
I've got a spare copy of this convention. You had it loose. I've had mine loose, and it seems to have disappeared.
Do you have a copy of the convention? Just take that out now. Yes.
We can share this, I think. So it's the law of the country is a relevant phrase.
Yes. So I'm going to make observations later at the end of this about why, in fact, it doesn't say rules of law. At the moment, we are dealing with the expression law of the country. Under the law of the country where the award was made, that's the test for this court.
And that's a geographical
Yes.
test.
Well,
Is that about seat or about...
It's seat. It's seat. It's got to be understood as seat. Otherwise, it would be totally random because you would make the award wherever... This is Hiscox and Outhwaite. Remember the case where... I can't remember who it was, a member of my chambers who signed... Bob McCrindle signed the award in Paris, incidentally, and it changed the seat. So, it's seat. That's the test we are applying. Doesn't say rules of law. So here, it's common ground, it's French law. My submission on this is that means, as interpreted by Mr. Justice Aikins and the Court of Appeal, the law that would be applied by a French court. It's not the law or rules of law that might be applied by an arbitrator sitting in France. That's different. Now, that takes me...
Do you get that simply out of the language?
Yes.
Applied by a French court, what, to a substantive question?
To this question,
Namely,
valid arbitration agreement.
whether there was a valid arbitration
Yes.
agreement. No room for principles of French private international law and anything of that kind.
It's not got a renvoi in it.
No.
And this was supposed to be, Albert Jan van den Berg makes this point, I'll get to the reference in a minute. This was supposed to be, in 1958, when the convention was drafted, a uniform conflicts rule.
What does that mean?
Meaning it would not have renvoi in it. It would be a rule, a simple rule, applied in all contracting states. And the policy behind it is pretty obvious in my submission. If you are going to have an arbitration agreement tested, you test it by the place where the legal seat of the arbitration being the closest connected place. That's the conflicts rule that they decided on. Once you allow for a renvoi, then the position becomes very complex. And certainly, as between 144 contracting states, it would be complex.
It's supported by the fact that at that time, and probably since, renvoi was almost universally excluded in contract matters. And since one of the heads is the agreement is not valid under the law to which the parties have subjected it, that undoubtedly would have been intended as a reference to the
law,
the internal law.
The internal law. I'm grateful for that. Mills, can I then...
If the arbitration clause says this arbitration agreement is governed by the law of X,
Yes.
then what?
You're in the first part of the conflicts rule.
Yeah.
You've got a law indicated.
So that would be the law to which the parties have subjected to it,
Yes.
or the putative parties have subjected to it.
But that would be the law of the country, X.
Yes.
But basically, I mean, the logical consequence of this ought to be that arbitrators who must have in mind that they are producing awards which are intended to be enforced under the New York Convention ought actually to adopt as the law governing the question whether an agreement is valid or not, the law of the seat.
Yes.
But they don't.
Well,
They detach themselves.
there are arbitrators who take different views about transnational validity and the application of transnational rules. The English policy on this, as reflected in Section 46 of the 1996 Act, is arbitrators should not overstep the mark. They must apply law, not rules of law or transnational law, unless the parties expressly agree otherwise. So looking through English eyes, for what it's worth, the answer to my Lord Mance's question is yes, an arbitral tribunal should have one eye on where likely recognition and enforcement may be, and not do something which is going to invalidate the award under the convention. If
No,
the parties...
they should look at the arbitration agreement,
Yes.
one, see
Yes.
whether it's governed by some law.
Yes.
If it is, apply.
Yes.
If it isn't, then apply the law of the seat.
Apply, yes. Or exactly. I mean, there's a golden rule in arbitration, which is you look at the end result and work backwards. You've got to do, whatever you do, must not impugn the award under the convention, because that's the end result. Article 5 has a normative
And
role.
the whole point of an arbitration is that it should be, the award should be enforceable under the convention.
Exactly. And that's the beauty of it. I mean, the convention is not a constraint, it is an advantage. But Article 5 of the convention has a normative value. It spreads back through the process. Everything that happens in the arbitration must conform with those minimum standards. And if you do conform, you have the advantage of international enforcement.
But the trouble with the difficulty, or perhaps one can sympathise to some extent with arbitrators in this light, is that the Cour de Cassation itself has invited arbitrators sitting in France to detach themselves from any state law.
I'm grateful, my Lord, because that's exactly where I need to go now. I've given you the structure of three elements: French law, conflicts for arbitrators, what arbitrators might do. Now I need to explain the first one. What is French law? What does the Cour de Cassation say about the content of French law? So if I've made that clear, can I now answer that point? This goes to the heart of the transnational issue. The French courts, we've gone through what an English court would do, which would be applying a conflicts of law analysis. The French court would not do the same. The French courts do not apply a conflicts of law analysis to the question of who is a party to an arbitration agreement or its validity. They have developed what in France is called a règle matérielle, a substantive rule, material rule, which the courts in France apply instead of going through a conflicts of law analysis. The origin of this substantive material rule is a transnational rule, a rule of international public policy and many other international norms. That's its origin. But the French courts are proud of that, and that's why there's some sensitivity about this decision. They like to say, as they have done in Dallah, the Dallah is the main case on this, which is the one cited by the tribunal, they like to say, we respect arbitration agreements as being above the level of national legal orders. They are special transnational agreements. We will test their validity by the French conception of international public policy.
I mean, suppose the parties agreed the law, they'd respect that.
Yeah, of course. They would, of course. This is all in the absence of agreement.
Yeah.
So if I've made that clear, this is what the French court would do. This is what they did in SPP pyramids. It's what they did in Dallah. They're not applying a conflicts. This is just for arbitration agreements. They're not applying a conflicts of law analysis. So they apply their substantive rule. They do so using the language of transnational law. I mean, to put it bluntly, if I may, this is perceived as a sort of selling feature of international arbitration. It's perceived as a sort of selling feature of arbitration in France, as being very pro-transnational and modern in that view. This is the Professor Gaillard perception of international arbitration, amongst many others. Now, the key point about this process, which I'm going to show you several authorities on this in a minute. The key point is, whilst it is called a transnational rule in France by the French courts, and whilst, as in Dallah, they articulate it in terms of being divorced from every national legal system, as a matter of analysis, it is French law. It's not a transnational law principle, because it's a transnational law principle that has been recognized, adopted, and evolved by the French courts.
And it's not a French conflict rule.
No. It's not a French conflicts rule. It is a rule of French law, and volume B1 is the law on it, which is French law. These are the French cases that we've been looking at. Ori. No.
Sorry,
B1, French authorities. This was the subject of the expert evidence in front of Mr. Justice Aikens. So can I put it this way? What's happened here is, in Dallah, the French courts adopted this idea of not using conflicts, going straight to what they say is transnational law to test the validity of an arbitration agreement. Since then, that principle has been refined and developed by the French courts. And that's why in volume B1, you've got a number of French decisions showing how the rule has been developed by the French courts. The French may still call this transnational law. Analytically, it is French law.
And does Mr. Justice Aikens expressly hold all that?
He,
or does he...
well, I think the point may not have been articulated so clearly in front of him. He makes a distinction, certainly, between transnational law, which is what the tribunal used, and French law. When he talks about French law, he's talking about this. And the expert evidence in front of him was on these cases. That, in my submission, is different to the transnational, pure transnational law, which is category 3 in my 3 categories of laws, that the tribunal applied. The two are not the same. They may coincide occasionally.
How do we distinguish them?
You distinguish them by looking at how the French courts have evolved the rule. You distinguish them by looking at the expert evidence before Aikens.
I see.
Is the result of this that if the tribunal had correctly applied these cases, then Article 5(1)A would have been satisfied?
Yes. Exactly.
So, transnational law is actually defined by what the French courts say is transnational law rather than by what the arbitrators say.
Exactly. That's French law. So the two important things are French law, which includes the règle matérielle, the substantive rule of transnational law, as adopted in French courts, and then wider, unlimited transnational law, which won't be restricted by these cases. Yeah. It will include other elements of good faith, alter ego, lex mercatoria. Can I make this good with a few authorities?
Yes, don't go
Anyway,
too
there's
fast.
no clear statement of Mr. Justice Aikens on this. No.
Well, there is a clear statement of a distinction between transnational law and French law.
Where is that?
Paragraph 93. Paragraph 93.
Paragraph 93
Of
the judge. Thank you
judges.
very much. Of Mr. Justice Aikens. Thank you very much.
5D.
Thank you.
93.
Yes.
So Mr. Justice Aikens says he has heard 3 days of evidence on the French transnational law rule, French law. That's evidence adduced by Dallah and the government of Pakistan. And he calls that French law, and he's correct to do so.
But he says these principles must be regarded as French conflict of laws rules. You don't accept that?
No, I think there may have been some slip, if I may say with great respect, in the distinction.
So he does occasionally nod, Mr. Justice Aikens, then.
Well,
Can't take him at face value. I thought your case was good.
well, that's one question.
So we've got to
answer.
choose the bits where he was right.
No, my Lord, this is not an easy topic, and I have to say, Dallah's case has changed, which is the problem, because they began by saying it was Dallah's case in the Court of Appeal that the tribunal didn't apply French law, they accepted, but they applied a test that was equivalent to French law. And now they're saying before this court, well, actually, French law includes transnational law.
I'm sorry, let me just get that straight. When were they saying that...
Let me give you the references. In the Court of Appeal, this is Dallah's Court of Appeal skeleton argument, paragraph 93. bundle reference A, tab 3, page 55. They said as follows: the tribunal applied transnational law, although in so doing utilised the same principles as French law. That's what they said in the Court of Appeal. So there was a coincidence between the two. Now, they say transnational law is part of French law, paragraph 53 of their written case for the Supreme Court.
And you accept that?
Yes, I accept it. Transnational law is part of French law, but as modified, evolved, developed by the
Just
French
that the
courts.
transnational law referred to in those two sentences is different.
That's right. That's right. Now, can I make that proposition good, please? With there's a bundle of further authorities that the respondents have put in. Additional authorities.
Wait a moment.
I mean, presumably, just going back to the question of whether this is a conflict of laws rule or not, that seems to me probably a verbalistic point, because presumably the French courts think that they are doing something other than apply French law. They presumably think that somewhere out there is something sufficiently definable as transnational law.
No, they accept themselves that this is, well, I say they. I mean, there are leading commentators, French commentators, who say in terms, this is even though it's called transnational law, it is French law. That's what I'm about to show you.
I can see that, because
Yeah.
I mean, insofar as they can't point to anything out there,
Yeah.
certainly not law, but really nothing. They must be inventing the principles themselves, and therefore one can say, essentially, this is part of French law. Conflicts rules only make sense if there is something identifiable outside the national system which you are referring
Yes.
to, rather than your own national
In
principles.
fairness to the nation of France, there are principles, transnational principles, that are recognised, but they're indeterminate. One can't say, Lord Mustall famously said, what is the lex mercatoria? I mean, there are people who analyse it and identify principles, but they are not. It's not one textbook on transnational law. There are general norms that might be adopted, and the French court doesn't see this as a conflicts
Yes,
exercise.
I think if in England we had a rule that all arbitrations between UK residents or nationals were governed by strict rules of English law, but if the parties were foreign, the tribunal could decide ex aequo bono as it determined. That wouldn't be regarded as a conflict, would it?
No. They don't see it this way. No,
Anyway, it doesn't really matter whether it's how you describe it, does it? What we're trying to find out is what are the relevant transnational principles which are part of French law.
Can I see where we're going? You were going to look at B1 at one point.
No, I want to take you to...
We can put that away. It's all in
the respondents' additional authorities.
And these are going to be the cases that support the point you're making.
They're not cases, they're commentaries.
Commentaries.
And what they say is that whilst this is called in France a transnational law principle, it's not, it's French law.
Are there any authorities then in B1 Part 2 that you ought to bear in mind? We can really pass them over just now.
You can pass them over. I wanted to
Go
show you
straight to
it's a visual exhibit, volume B1, for my purposes at the moment. It comprises the cases on which are French law, which are the transnational bit of French law. And those are the cases which were put in evidence before Aikens by both parties. That is the evidence he decided upon. It is French law, including the French conception of transnational law. It's different from what the tribunal applied, which was transnational law without the constraints of these cases.
Well, where is the clearest statement of the constraints, if you like?
Ori. Not just Ori. I mean, I can't give you one statement. One is the principle in Ori, which talks about the formulation of an acceptance of the arbitration clause, the formulation I showed you. The other constraints were the ones which were articulated by Monsieur de Reims and Vattier in evidence.
Now, are they clearly articulated in a section of your case?
Yes.
That one can readily identify without having to make a note of them separately?
Page 14 of my written case, I have set out the relevant principles, in summary. And these are These are points about, firstly, how you articulate common intention.
Sorry, which paragraph in the case?
It's from paragraph 29 of my written case. Sorry, paragraph 30, actually, relevant legal test. Now, to guide you through this, what happened in front of Akins was detailed debate over 3 days about a number of rules of French law. It's the transnational law element of French law. For example, how do you distinguish between subjectivity and objectivity? The answer is given as a matter of French law. They might be thinking it's transnationally based. It's French law. How do you deal with a state as a contracting party in French law? What are the rules governing a state? Let me give you a specific example.
I think probably the most important question with which we're concerned is this, isn't it? What parts of the tribunal's decision
are different,
are not part of French law?
Yes, that I'm going to show you.
That's the critical point.
That's the critical point.
Rather than trying to work out.
That's the critical point. It's a much,
I see you have clearly set out here.
It's a much easier way into it. Yes.
So what course are you going to take then? Are we going
the course I'm going to try and keep, but I'm coming to my Lord's point.
Yes.
Is can I show you?
So we are going to be.
I want
we're going to
these
these
further authorities to
Yes.
make good my proposition that there is the transnational law element in French law is actually French law.
All right. So we go to the
additional
this-
authorities, respondents' additional authorities. After that, I will come to my Lord Clark's point as to show what tribunal did was different.
Yes. Right.
And how, just one footnote.
Please.
How do these principles differ from the principles that a French court would apply if this were a wholly French case?
It's the same.
Yeah.
It's the same. This is SPP pyramids. I keep mentioning that case, and I'll be guided by the court if you need any elaboration on it. But SPP pyramids, it's a case which is almost identical, apart from in terms of principles, to this case.
But that wasn't a purely French case, was it?
It was not. No, it's an international arbitration
Egypt
taking
or something,
place.
yeah.
Yes, it's Egypt. This
But
is
what I'm asking is, the principles in these cases,
Yes.
the transnational
yes.
situations, how do they differ from the principles the French court would apply in a purely French case?
I'm told by Monsieur Angenot that if it's a purely French case with no international element, there would be different rules. That there are French domestic rules on arbitration. So these are rules of international arbitration.
Which don't rely on the common intention.
What, the domestic rules?
Yes.
That I don't know.
It's very unlikely that they don't.
It's unlikely, but yeah, it's unlikely. I suspect that the analysis is different because it's not by reference to a transnational legal order, which is the cornerstone of international arbitration in France. But I'm afraid I'm not in a position at the moment to help on that as to the French domestic rules.
Right. Are we going to?
Yes. Can I ask you, first of all, to turn in my bundle of further authorities to tab 4?
Yeah.
Now, are these authorities referred to in your case?
No, they're not. These are the only ones not referred to in my case.
So this is new material, not
It's new
seen by the
material.
Court
The
of
reason
Appeal.
I have sought to introduce it after my written case
Right.
is because of the further elaboration or further understanding, perhaps on my part, of Dallah's new point before this court that transnational law is part of French law, and therefore the tribunal applied French law. That's why I've sought to introduce these further authorities. And what I'm doing with these authorities is making good my distinction between French law, with that substantive law element of transnational law, and unconstrained transnational law.
Sorry, have we gone to tab 4 in which
Tab 4 in the bundle of respondents' additional authorities.
Yes, that's what I got. Yes, actually, this
Poudre-Besson is a leading textbook in international arbitration. May be familiar to some members of the court. There's a heading 3.2.3, validity of the arbitration agreement independently of any national law. Now, I don't want to take time reading all of this. Can I point you to the bits that I rely upon? This is an analysis of the principle in Dallah. Remember, Dallah is Cour de Cassation decision where they start enunciating this. we do not apply any national law. Picking up from the second paragraph under 180, according to Jean-Pierre Ancel, thus was confirmed the principle pursuant to which the validity of an arbitration clause in international contracts resulted solely from the will of the parties, independently of any reference to the law of the main contract and to any national law. This is the ultimate pinnacle of autonomy. So that is what the French courts are doing.
Well, but if it's true that that's what is happening, then you couldn't possibly fit it within the language of Article 5(1)(a) because you wouldn't be referring to the law of any country.
No, my lord, forgive me, this is the point. It is this principle...
So it must be a principle of French law.
That's the point.
Yeah.
They call it transnational. In truth, it's French law.
Otherwise,
Can I continue?
otherwise, it'd be no good for them because they wouldn't
Exactly.
be able to. It wouldn't work under the Rome Conventions.
Exactly.
Under the
New
York.
Yeah.
Sorry.
New York Convention, exactly. Can I continue? Is it not rather, as Fouchard, Gaillard and Goldman noted, the result of a skid of terminology, which probably is an unfortunate translation? For it is only the first two aspects, i.e. indifference to the fate of the main contract and the possibility of being submitted to a separate law, that flow logically from the principle of separability. The latter by no means implies that the arbitration agreement is independent of any national law. The real justification of this regime lies elsewhere. As Philippe Fouchard emphasizes in his note on the Menekucci judgment, the aim is to remove the obstacles which certain laws, including French law, bring to the development of international arbitration. Although the judgment does not say so, this new conception of separability implies abandoning the conflicts of law approach in favor of material rules. Okay, those are the règles matérielles, which I mentioned, which are in reality part of French law and not of any international or transnational system. We shall see this point with the Dallah judgment. That's the point. The French will call it transnational law because of its origin, but it's French law.
So it's got nothing to do with conflict of laws.
No, it's avoiding a conflicts approach. The same point is made by...
And the reason why they're introducing these transnational rules or applying them is what? To make French arbitration seem particularly international?
Yes.
It's
more than
that's not intended to be a criticism.
I mean, my answer is sounded clear. It's more than that. It's because there is a perfectly respectable French conception of international arbitration. We haven't shared it traditionally in this country. That the process the arbitral process gets validity not from the law of the seat, but from some free-floating transnational legal order. That's the French conception. It's set out in detail in Monsieur Gaillard's recent book on the philosophy of international arbitration, and it's absolutely coherent. We may not share it in this jurisdiction, but it explains the Cour de Cassation's approach.
Well, the other explanation seems to be hinted at here, namely that French domestic law relating to arbitration is pretty technical.
Exactly. That's the other motivation.
Yeah.
The other motivation is to avoid the complications and restrictions of French national law.
Yeah.
So this is an international arbitration principle,
Yes.
really, in effect, which has been developed. And is this to resolve the question at the beginning of the paragraph?
Yes.
Which is that the validity of the clause is to be determined solely from the will of the parties,
Exactly.
which is presumably, I don't see this written out, but presumably not the way domestic law would look at it for internal arbitrations.
If I've understood it correctly, in Dallah it was being used to avoid the application of Libyan law as the governing law of the arbitration agreement.
I think that may be so. I'm now speaking from memory on Dallah. We can look at that in a minute afterwards. But certainly, partly it's detaching from French legal constraints. But importantly, the Gaillard theory is to also detach from the law of the seat. That's the transnational conception of arbitration. That you're not looking at the law of the seat as the source of authority for the process. So if that was outside France, it's the same principle.
Well, I think it was a French arbitration, but
Yeah.
arbitration agreement governed by Libyan law, and they avoided the
That's right.
application of
That's
ordinary
right.
rules of French private international law.
I believe that's right. My Lords, can I just take you to another excerpt over the page of the same document, same point, paragraph 181?
Yes.
Having recited the case law, which is partly in bundle B1, my visual exhibit that was before Aikens, Courbet-Besson say, the result of this case law is that the arbitration agreement is subjected to a material rule, in contrast to the conflicts principle, which recognizes its validity, provided it does not violate international public policy. Although this has been the subject of controversy, the rule is an international rule of French law and not a transnational rule. He cites there to an influential note by Professor Pierre Maillère, who is a leading French academic in arbitration law. That article is in French and English in the previous tab 3.
Is that the second last footnote?
Yes. Maillère with a note on the Duclair judgment, the review arbitrage. I needn't go through the whole of this Maillère article in your collective notional spare time.
This is paragraph 3. Sorry,
tab 3. You might want to look at it. But if I can just draw your attention to one paragraph on internal page 3 to 4 of the English translation. Professor Maillère is sensitive to the criticism that's made about this approach from other non-French commentators, that it may be imperialistic. Why is it that a French court can somehow itself apply its conception of transnational law in this way, arrogating to itself somehow what international public policy is? Maillère's answer to that is, it's not, because it's French law. It's the French view of international public policy. The last paragraph on page 3 of this article, considered on its own, the thesis of the contract entirely outside state law arises out of well-known theoretical objections, which, while not irrefutable, need not be revisited here. All that is needed is to highlight the curious phenomenon that occurs.
It doesn't say arises out of, actually, it says raises. Raises well-known theoretical objections.
Raises well-known, yes. I'm grateful.
Translation.
The curious phenomenon that occurs when a state court wishes to consecrate it. The contract ceases to be outside state law when the court declares that it is valid irrespective of any state law. It's exactly what is happening here.
So this is the court declaring as a matter of French law, presumably.
Yes. Indeed, such a declaration constitutes the particular reaction of one legal order which may differ from that of another legal order. By virtue of the fact that the arbitration clause included in an international contract is binding on the parties and must be applied irrespective of any law, whether state or otherwise, it is in fact a rule of French law that the Court of Appeal states and applies to the clause at the same time. Although it reserves the affirmation of a principle of intrinsic validity of the clause to other hypotheses, as we will see later, such a principle is no less implied. So it goes on.
Yes.
Now, the point for our purposes, my lords, is that this is the French interpretation of international, transnational public policy, whatever one calls it. That is reflected in French cases. Those cases were the subject of detailed expert evidence from both sides in front of Mr. Justice Aikens. Those principles were found as a matter of fact and applied to the facts. No evidence was put forward by Dallah at any stage of transnational law outside of the French courts, wider transnational law. The court's never been assisted with evidence on that.
I mean, when for example, in tab 4, paragraph 180, the author says, this judgment contains an important clarification, namely that the common intention of the parties is subject to mandatory rules of French law and international public policy.
Yes.
Are both those notions, namely the mandatory rules of French law and international public policy, are they all part of what you call the transnational law?
French law.
Sorry.
The French conception.
Well, sorry, the transactional principles which have been adopted by French.
Yes. Can I make that point good by one other authority, then I'll put this bundle away, which is Fouchard Gaillard Goldman. That is tab 2. This was a passage, or a series of passages that my learned friend took you to, but in a different context, I believe. I'm not going to read all of these, but this is Fouchard Gaillard Goldman making this precise point. They talk, if one starts from internal paragraph 439, the heading is Scope and Merit of the Substantive Rules Method. My lords, the Substantive Rules Method is the one which I'm talking about, the règle matérielle, which is avoiding conflicts of law, the idea of going straight to a principle. From paragraphs 439 over to the end of 442, Messrs. Fouchard Gaillard Goldman make the point that this is the French conception of international public policy. It's not international public policy, full stop. It is the French conception of international public policy. My lords, I'm going to be conscious of the time, unless your lordships want me to. I'm not proposing to read through these paragraphs. But that is my Lord Clarke's point is in terms, is addressed here, because each time Fouchard Gaillard Goldman talk about international public policy, they do so through the prism of the French courts or the French conception. Why does this all matter? Because under Article 5.1a of the New York Convention, you are to apply French law. French law includes a substantive material rule.
It's, sorry to interrupt you,
Yes.
it's put very nicely, I think, in paragraph 441, where it said that, middle of the paragraph, this understanding of the expression public policy consists of the French legal system's view of the fundamental requirements of justice in an international context. Yes. So it's detaching itself from the domestic view in this particular context, the international context. It's a French conception.
Exactly, my lord. And it's the same point that gets repeated in these other paragraphs. It's that point. So I'm hoping where I've got to at this point in the analysis is to have made good that we are dealing with two universes. One is the French view of transnational law, that's all French law, and that's all permissible under Article 5.1a of the New York Convention. You've then got this other universe, which is not tied to Bundle B1 and the French cases. It's much more free-floating. It's not through French eyes. And that is not the law of the country where the award was made.
Does this take us then to what the tribunal did?
Yes. Now, in looking at what the tribunal did, in fairness to the tribunal and in fairness to my learned friend, there is an element of surmise, because I cannot say, honestly, that the tribunal definitely did not apply the French cases. They definitely did not look at them or were not influenced by them. It's very unclear from the award. The best that one can do is to look at the test that the tribunal actually articulated and then point to what may be, on a fair view, points that they have missed, which Messrs. de Reims and Vattier testified on as being French law. One has to go through this exercise. It's not good enough to say, well, it looks similar, which is what my learned friend's position is.
And where is this in your case?
This is not set out in this way in my case.
But you do have a...
I've got a lengthy analysis of all the mistakes they've made.
That's in the appendix.
And Appendix A.
Yes.
Well, none of the members of the tribunal was a French lawyer.
No.
They may apply French law in the Lebanon, but one wonders how...
No, can I make this other point along the way? It's said against me that Mr. Justice Aikins was in no better position than the tribunal. There was no new evidence. But the whole point of the 3-day hearing in front of Mr. Justice Aikins was to have detailed analysis of the French test, with live testimony from Maître de Reims and Monsieur le Bâtonnier Vattier. That was not before the tribunal. And that's the point about who is a party to this arbitration. It's the key essential evidence, whether you call it evidence or submission. It's French law. That was not put before the tribunal. And there's a good reason for that. because the case wasn't argued on that basis in front of the tribunal. It was argued as alter ego and succession. The first time that the issue of common intent, or the French test, was raised was after the end of the hearings in the arbitration in a letter written by the chairman, Mr. Mahmasani, to the parties. That's noted in the written case. The evidence had finished, the hearings were over. Mr. Mahmasani says the tribunal's been thinking about this and wonder whether, in addition to...
Do you have the letter?
Yes. It's in Bundle D, and it is at tab 9, A9. Actually, just... Yes, 9, tab 9, sorry.
Under what? B, did you say?
D Delta.
D for Delta.
It's a letter written 29th of November 2000. Now, this is after the end of the hearings. The case has been argued on alter ego and succession. If your lordships have that, it's you can see from the letterhead, Mr. Khalid Mahmasani, to the party, to Kearns & Co. Actually, it's addressed just to Dallah. I don't know, as a matter of fact, at the moment, whether this was received by all parties. I have to assume it was. Copied. Thank you. Thank you very much. Copied to the government. Dear sirs, after discussion with the other members of the tribunal, I respond to your letter dated 24th of November 2000. Now, at the moment, I'm not sure what that letter is, but can I read on? In the first place, tribunal shares your concern about the passing of time. Conceptual and practical problems raised by the issue of jurisdiction, by no means easy in themselves, have been made more difficult to solve by the geographical separation of the arbitrators. All right. The next paragraph is the important one. This leads me to the conceptual aspects of the dispute. The tribunal is, of course, clear about the general nature of your client's case, but has, in the course of discussion, become uncertain as to its precise juristic base. In particular, it has struck us that there may be implicit in that case, though not expressly articulated, a proposition similar to the one which has been adopted in several ICC awards. Now, if I can inject some submission into this, my submission is that's a reference to Dow Chemical and the Dow Chemical line of ICC awards.
We have Dow Chemical.
We do. We do. It's in bundle B1, my lord. And the reference in B1 is at... well, actually, forgive me, we have the Paris Court of Appeal in Dow Chemical.
No, we have that.
And the tribunal. My lord, I'll give you the reference in a moment, if I may. It is not, of course, for us to redevelop your client's arguments, but we think it right to inquire whether they rely on the line of reasoning embodied in, for example, the Pyramid and Westland cases.
And what is that?
Well, the Pyramid case is the SPP Pyramid.
Yeah, but what's
case.
the reasoning?
Well, the reasoning is I suppose, loosely based on the French approach of common intention, but unbounded. It depends what they're referring to by pyramids, whether they're referring to the French Cour de Cassation, the French Cour d'appel, or whether they're referring to the arbitral award. I mean,
It looks like the award, doesn't it?
And they're talking about ICC awards. In fairness, I don't know. So in fairness, one may assume that they have in mind what the French courts do as well. In fairness, they have referred to Dallah in the award. The difficulty this court has is that one just doesn't know. One can't make the confident assertion that Dallah makes that the tribunal applied French law. It's just not articulated sufficiently to know that. And it looks like they
What did Dallah say in response to that?
we don't have the response.
But I mean, they're obviously expecting a response, the arbitrator.
It's not in the record. When you get to the award...
But the reason why it's insignificant, or potentially
Yes.
significant, here with the arbitrators writing to the parties,
Yes.
saying, what is your case?
Yes.
And we're looking
my lord, the
at
answer
the
is-
award, but it's
Yes.
very odd that we aren't looking at what their case was then said to be.
But, my lord, we have the statement of their case by the arbitrators in the first partial award. If I can take your lordships to that, which is significant. In the first partial award, there is a summary of Dallah's case.
But that may have been one of the first things to be drafted before response to this letter was received.
Maybe it was, but
So
one would think that if one takes this award at face value,
yes.
the statement of the parties' cases comes
Page
in
9.
It's internal page 9. I'm grateful. Internal page 9. Summary of the claimant's arguments. Heading number 1. The alter ego argument. And then over the page.
Now that's not the new point, is it?
Nope. That's the way they argued the case. And then 2 pages on, page 11, heading number 2, the Article 264 argument. Now, that is a succession argument. They're referring to Article 264 of the Constitution of Pakistan, which is an alleged basis for succession. It was precisely the point that was abandoned by Dallah in front of Mr. Justice Aikens. That's it. There is nothing after this. The next heading is on proper law and various other issues.
So where is their case of common intention?
We have no record of it. And
That's what was contemplated on in the document we're just looking at.
Yes.
So we don't know what
We
they
don't
said.
know. It's not there, and it's not recorded anywhere in the award. And it rather explains, again, I'm in submission suggesting, it rather explains the oddity in the reasoning of the tribunal, because the tribunal end up with an amalgam of alter ego and what they thought was the real point, which was common intention. And it may be that they were not assisted. They certainly weren't assisted by another hearing.
Yeah, 7 months after this letter.
Yes. But it does explain the reasoning as being an amalgam, and that amalgam may be perfectly acceptable as a matter of what arbitrators can do in France, sitting in France, applying my second category of broader transnational principles. But alter ego is not part of the French common intention test. So can I come now, and this is a section of my submissions that has to be surmised, because I'm doing what I can with the award.
I mean, what would if it was an alter ego case?
Sorry.
If alter ego was established, what would
Yes.
the position be then?
If alter ego had been established, then
Well, I suppose then they'd be the government. So
they would be the government.
So the trust would be the government.
The trust would be the government.
query what happens when the query.
Well, what would happen?
Anyway, there might be more scope for argument about that.
Yes, and actually, I mean, just to answer that point, my lord, when we rolled up in front of Mr. Justice Aikens, we had a daunting number of files on Pakistani law, because they began this case running an alter ego and succession case. When we got to the argument, the hearing, Dallah abandoned alter ego and succession and that Article 264 point. That is recorded, my lords, in paragraph 58 of Mr. Justice Aikens' judgment, and I think from recollection 76 to 77, or thereabouts. He records what happened. What happened was, I cross-examined Maître d'Arras, I cross-examined Mr. Pirzada, who was their Pakistani law expert, and then Mr. Justice Aikens cross-examined Mr. Pirzada, and the Pakistan law case on succession and alter ego fell away. Dallah abandoned it. So we're now in a different territory to where the tribunal were. I mean, that's the oddity in this case. We're trying to support an award on this slim plank. I have to accept that the issue of common intention was open before the tribunal because of that letter they wrote. But we don't know how they dealt with it. And when we come back to the point now about was it the French test, you cannot, in my submission, make that finding that they applied French transnational law.
You gave us the paragraph number where Mr. Justice Aikens recorded the abandonment of the alter ego and 264 points. What was that paragraph?
58.
58.
58, and also, I think let me check because I'm doing this from memory. I think it's 76 as well, where 58 records the points of agreement between the parties, and you'll see there that alter ego is abandoned. Yeah.
But your basic point.
Well, it's recorded actually in 70. Can I just find the point? I think I may have just given you.
It's in the facts and issues, isn't it?
Yes, but just in Mr. Justice Aiken's judgment, he records the exchange that happened with Mr. Pirzada. That was on succession. All right, let me correct this. I'm corrected
72
properly.
has a heading,
72.
issue no longer being pursued.
72. I'm grateful. I'm sorry, I was trying to do too much by memory. Can I clarify? My learned friend has helped me on this.
Your basic point there is that whether or not the tribunal applied or thought it was applying the common intention test, we have to reapply it
Yes,
and come to our own conclusion.
My Lord, that is the bottom line of all of this. I'm identifying for you at some length the difference between French law and transnational law to make sense of Article 5.1a and, in truth, to diffuse some of the criticism that's wrongly been made of the Court of Appeal judgment. Because the world has not understood that there is this difference between transnational law and French transnational law, and the English court has properly applied French transnational law. But the big point, and the only point that ultimately matters, is it makes no difference. Whatever the tribunal did doesn't change the nature of the examination by the court. The court must relook at it and come to its own determination.
Can you, Ms. Heilbronn mentioned that there'd been some criticism, and you mentioned some sensitivities, but
Yes.
Ms. Heilbronn simply referred to the blog, as I recall.
No,
is there anything else?
Yes, there is. There's
something
one article. I'm reluctant to refer to it because it's misconceived, but I'll refer to it as why I'm addressing this point in some detail. It is in the Cahiers de l'arbitrage, and it's by Cuniberti. Professor Cuniberti. Is that the one that you use? All right. No, I thought it was the other one that was critical. No, it's all right, they're two critical articles in the Cahiers de l'arbitrage, which we can hand up, which may be helpful. But what
Has Ms.
essentially-
Heilbronn, you've seen this?
These are the ones that my learned friend referred to.
I see, all right, yes.
The misconception in these articles is that the English court is acting in an insular fashion, the Court of Appeal,
Right.
and has read French law excluding transnational law.
Yes.
Now, the answer to that is no, it has not. It has read French law, including transnational law, properly. And that was what M. de Reims and Vattier testified on. The difference, however, is the English court, quite properly, under the conflicts rule in Article 5.1a of the New York Convention, is not looking beyond what the French court would do. It's not looking at some open-ended, non-French transnational law, which might include good faith, might include lex macatoria, might include anything else, alter ego. That is the point. And I think once the world understands that point, then it makes sense, because what the English court has done is no different from pyramids, SBP pyramids. It's the same principle that the French court applied.
So we have to write something that the world understands.
Well, I hesitate to give a mandate such as that, but when one talks freely in this field about the Mutual Association for International Arbitration, sometimes abbreviated as MAFIA.
Are there reports of the French experts in the bundle?
Yes, bundle B1. Bundle B1.
Yes.
Sorry, bundle B, French law. There are sensitivities generally because arbitral seats compete for business. And this is not a substantive point. I was saying there are sensitivities because arbitral seats compete for business. So people are ready to point the finger.
Of course.
Not where I was going, and I'm going to ask now whether the court needs me to go there, is to give some examples, if I'm by submission, of where I think the tribunal might not have applied the proper test.
Are these listed in your case?
They are all in my criticism.
I thought they were in Appendix B.
They are. Well, Appendix B is different. Appendix B are the new points that I raised for this hearing,
Yes.
which analytically is inconsistent with their case.
Right,
Because they
so-
should be just relying on the
So we're
tribunal.
really looking at...
It's Annex A.
Yeah.
The only thing, I could do this shortly, all my criticisms of the tribunal, the ones which I made before Mr. Justice Aikens, the ones which he found, and which the Court of Appeal confirmed, are all set out in my written case. They're summarised in Annex A. What I can do now, insofar as it may be of assistance to round off some of these points, is just to give some examples for each of these criticisms, there may be a response, well, no, the tribunal did do it properly, but in the end, the court can't rely upon what the tribunal has done. It's insufficiently articulated. So let me give you some examples. It was the evidence of Monsieur Derain and Monsieur Vattier, and accepted by Mr. Justice Aikins, that you must test the intention of all parties, Dallah, the government of Pakistan, and the trust. That was their evidence of French law. If you look at the tribunal's articulation of the test that they're applying, they only mention Pakistan. So you find their test articulated in the first partial award at internal page 26. Paragraphs 6 and 7. This is a key difference between what they did and what the evidence was in front of Mr. Justice Aikins and what he found. If I can take the Lordships, if you have it, at paragraph 7, internal page 26, first partial award. The tribunal state this: in the light of the foregoing rules and principles, i.e. the test that they are applying, the arbitral tribunal will look into the actions of the defendant. That's Pakistan.
And the foregoing rules and principles are what?
Arbitral as well as judicial case law in paragraph 6.
But they don't identify it more explicitly.
No. And the only...
Well, the reason why they're looking at the defendant is because they're asking the question, what about a party who didn't actually sign the main contract but was so-called directly involved?
Yes, but that's not the French law test. The French law test says you must look at Dallah and the trust and Pakistan because it's a test of common intention. Everybody has got to have the same intention at the same point in time.
And they say that in paragraph 6.
But then they say it in 6, but in 7 they've articulated what they're... Again, I want to do this fairly. I'm reading this critically. But we get no indication from here that they're spelling out the test in the same way as it was spelt out in evidence in front of Mr. Justice Aikins. Now, when they come to applying this test to the facts, they then don't look at Dallah.
I mean, paragraph 6 isn't too bad as a general statement of the position, is it?
As Monsieur Vattier testified, you were shown this in the transcript by my learned friend, he says broadly, for what it's worth, there's a coincidence of tests. But it's not enough, it's not detailed enough. And we spent 3 days after detailed expert reports going through the detail of the test in front of Aikins.
Your point is basically, anyway, all they did was look at the defendants.
And that's what they did. When you
conduct.
when you go through their application of this test to the facts, they haven't tested Dallah's intention. All right, put the trust aside. They should look at that as well. But where have they looked at Dallah's intention? Where do they test that? Where do they see how Dallah instructed their lawyers or Dignam? I showed you that letter yesterday, when they instructed their lawyers to draft the agreement in the name of the trust. Well, they haven't tested that. Where do they analyse the change between the MOU and the agreement from Dallah's perspective? Not done. Done by Mr. Justice Aikins and confirmed by the Court of Appeal. Can I point you to the Court of Appeal judgment, and to save time, if you allow me just to give you the reference and read it, paragraph 36 of the Court of Appeal judgment. This is what the Court of Appeal said. It is interesting to note in this context that although French law directs the court to the common intention of the parties as the foundation of any agreement, little attention appears to have been directed to the question whether Dallah demonstrated any intention to enter into an agreement with the government of Pakistan. This is my point. If it did intend to do so, it is surprising, to say the least, that it was content for the government neither to be named as a party to the agreement, nor to sign it in any capacity, and that it did not seek any other formal or informal statement of its intention to be bound. So that is the Court of Appeal making this point. The tribunal has not applied what the test the French courts would do. If I can just make this good further, if your lordships get the time to look at SPP against pyramids,
What's the reference to that?
that is bundle, actually, it's in two places, and most conveniently it's in the authorities bundle.
Tab 23 or 4, if it's the Court of Appeal and Court of Cassation, or you
Let's
get...
see, well, the Court d'Appel is where the full reasoning is. Court of Cassation is a short confirmation.
This is volume 1 of the authorities, is it?
Volume 1 of the, no, it's volume 3, I believe.
It's B1, isn't it?
Oh, well.
Sorry, yes, it's in B1
It's in
if you have
B1,
it there.
yes.
I can give you another reference
Which
if you
tab
need
in
it.
B1?
Fine. Bundle B1, I don't
Tab 23.
So the full analysis is there. I'm not going to take time now going through it, but it was confirmed by the Court of Cassation subsequently. What is interesting, though, apart from the uncanny parallel of facts between pyramids in this case, it is uncanny, actually. By quick footnote, this case was about building some monstrous hotel in Mecca, near the Haram Sharif, the main shrine, and SPP Pyramids was about building some monstrous complex just by the pyramids. In each case, the government began by being a party to a heads of agreement, or MOU, and then changed with a subsequent contract where the government was no longer a party. The parallels are uncanny throughout this. What's interesting about the pyramids analysis by the Paris Cour d'Appel is that they carefully apply this test of looking at each party. They look at the subjective intent of three parties in pyramids: the government, a government entity, and the investor. That exercise was not done by the tribunal. Now, my lords, with your permission, I won't go through that now because I'll take up too much time. But that is something which can be looked at, and in my submission is exactly what the French courts, the test of the French courts that you are to apply under Article 5 of the New York Convention. My lords, if I can go back to the track I was on of criticising the award, let me give you another example. Nowhere in the articulation of the test by the tribunal do we get the statement that I pointed you to in the Ori case. Paris Court of Appeal, bundle B1, tab 22. We do not get that articulation. We spent time in front of Mr. Justice Aikens getting to that proposition with questions to Monsieur Dallas. You cannot see it anywhere in the articulation by the tribunal. They may have had it in their heads, in fairness to them, but it's not clear that it was there. Next point.
It is fair to say that the whole of the analysis of the tribunal is really predicated upon their paragraph 7.
It is. It is.
Because every subsequent paragraph deals with the 4 sub-paragraphs of paragraph 7.
Exactly.
And even when you get to the end, paragraph 12, from the aforementioned close scrutiny of all the factual elements related to the conduct of the defendant, it is clearly established that. And then we have the alter ego point.
Well,
and then even 12.2, which
and then after 12.2...
is also particulars, or said to be particulars of that.
That's right. But then you get this equivocation that happens after that, where Lord Mustill and Dr. Shah are hesitating.
But it's only really when you get to paragraph 13 that you get away from that.
Yeah. Now, my lords, can I take my Lord Clerk's point further? Because the next point to make is that when they're going through this chronology, the test, the French law test, was you take into account all the factors in the sequence. That was common ground, and it was then found by Mr. Justice Aikens. They haven't done it. They go up to the 97 Pakistan proceedings. They jump over that and go to the 98 proceedings. But they haven't looked at 97 and 99. Now, again, this may be unfair criticism. Maybe it wasn't in front of them. Maybe they did look at it but didn't articulate it in the award. But you can't confidently say that they're doing the same exercise because they're not looking at the whole sequence. They are, in the words of the Court of Appeal, impaling the government of Pakistan on an isolated admission. And that's not the French law test. That's the reference I've just given you is paragraph 41 of the Court of Appeal judgment. My lords, can I give you another example? There was evidence before Mr. Justice Aikens that the French law test is to be applied in concreto, meaning that you have to apply it realistically to the particular facts, the particular parties, and in this case, that meant a state. There was a refinement, several refinements of the common intention test as a matter of French law, French transnational law, when applying it to states. I'll list these quickly. There was an acceptance by the French experts and by Mr. Justice Aikins, recorded in his judgment at paragraph 91, Mr. Justice Aikins' judgment, that you have to, when applying this test, bear in mind that as a matter of French law, the Cour de Cassation decision in Crichton and Qatar, a French state that agrees to an ICC arbitration governed by French law in France will be taken to have waived its sovereign immunity, not just with respect to jurisdiction, but also with respect to execution. Okay, now that's a French Cour de Cassation decision. In France, they say that the ICC rules include a waiver of sovereign immunity, not just jurisdiction, but also execution against state assets. We haven't taken that view yet in this jurisdiction. But what was held in front of Mr. Justice Aikins was that because of the importance of that, that is a factor to be taken into account when deciding whether or not the state really has agreed that.
But presumably there can be a clause in to protect state immunity.
Sorry?
You can contract out of the
Of course you can.
exclusion. So,
Of course
you
you
would
can.
expect if the state was actually making
Absolutely.
itself party to find a clause to that effect, as
Absolutely.
I think you find in the MOU.
Absolutely.
There was a case on this going to the Court of Appeal, but I think it was.
I'm
it was
afraid
settled.
it's settled,
Yes.
unfortunately, just as we were about to argue it. The point here is it's Article 24 of the old ICC rules, which was analysed in Crichton, Qatar. It's Article 28 of the current ICC rules. And it's got a provision which says the parties undertake to carry out the award. And the Cour de Cassation in Paris has interpreted this as amounting to a waiver of sovereign immunity with respect to execution. It's a very extreme position. Where this is relevant for your lordships is, before you come to the conclusion that the state has agreed, bear in mind, in so agreeing, it's taking a big step because it will be exposing its assets. And therefore, it may be...
Well, it knew it was going to do that, really. If it was a party, didn't it see the MOU?
No, I mean, of course, this is, there's a notional
it's all
element.
very well. I mean,
I take, of course, it's notional. Nobody may have put their mind to it, but it was part of the French test as articulated in front of Aikins. It's not anywhere considered by the tribunal. All I'm doing is highlighting the differences. And I won't take this so far, but can I just make a couple of other points on the significance of state? There is the question of Article 173 of the Pakistan Constitution, also held to be relevant by the French law experts. Article 173 of the Constitution, you may recall, is the provision that either mandates or recommends, there was an issue about that any contract, if it's going to bind the state of Pakistan, is made in the name of the president. You will recall that the MOU was made in the name of the President of the Republic. The agreement wasn't. Mr. Justice Aikins, at paragraph 103 of his judgment, said that this was a relevant factor. The tribunal did not consider it. The French law experts had confirmed and agreed that this would be a relevant factor in the French test. My Lord, I'm not going to continue anymore, but these are the points to suggest that there is a difference. And where it comes to really is, it's just not good enough for Dallah to say, well, the experts broadly agreed that the test applied by the tribunal was the same. That is weak analysis, if I may say with respect. There was no evidence before Aikins on the kind of test that the tribunal purported to apply. In the end, all that this court needs to rule, in my submission, is that, firstly, it doesn't make any difference, because the court has an ability to come to its own determination. Secondly, what Mr. Justice Aikins did and the Court of Appeal did was entirely proper under Article 51A. They applied French law, which is what Article 51A mandates them to do, and in so doing, they applied the transnational law elements of French law. I may have exhausted all members of the court at this point on this issue, but there was one other aspect that I was going to mention, and I'll raise it to see whether it causes any interest at all. I believe I've now covered the difference, the definition of transnational law, the definition of French law. The one other remaining strand in the analysis, which may or may not be needed, is to understand the difference between the word law in Article 5.1a and the expression rules of law. It was a point that my Lord Clerk raised earlier. The only reason to mention this is if and insofar as the court wants to come to wants to explain the use of the word the law of the country in Article 5.1a rather than why it was that in 1958 they may not have used rules of law.
Well, where might they have got rules of law from? Is it anywhere in the New York Convention?
Nope. My point is it was not included in the New York Convention. I'll give you the quick summary of the point.
I mean, what do you mean by rules of law? Something like, you gave an example, the international sales of goods.
Rules of law has a settled meaning.
So the law of Mercatoria and so on, these sort of things would fall within that.
Yes.
International principles.
The key distinction between law and rules of law is whether or not it's tied to one definable legal order, national legal order. A law are the rules and principles of one definable national legal order, and rules of law are international or transnational norms not tied to one legal order.
Now, I think you made this point earlier, and I asked you what is the basis for saying that when the word law is used in the New York Convention, it means the law of the country. Is it just
it says the law of the country.
That's what it says, is it?
Yes, it says the law of the country.
And it's common ground.
Suppose they'd agreed,
Yeah.
that that the validity of the arbitration clause should depend upon the principles of ex
no problem.
Well, now, how does that fit in with the wording of the convention?
It comes in the first part of the conflicts rule in Article 5.1a. That will have been,
or the said agreement is not valid under the law to which the parties are subjected to. On your analysis of law, that wouldn't work.
That issue is there. And the point about all of this is that
I think we should be analysing.
Well, and of course, and the worst time to do it is 3 minutes before lunch. But can I just make the point that we are dealing here with a document that is now over 50 years old. 1958, that it was settled. At that time, nobody was talking about rules of law. Rules of law came out of...
Maybe they weren't. I'm only on the point that if we're trying to identify what's meant by law in Article 8, Article 5.1a, it has, in the expression under the law to which the parties have subjected it, it has at least potentially a fairly wide...
No, that surely wouldn't embrace non-national laws. The only way they'd come in would be as matters which were contractually agreed under the law of whatever country was relevant.
My Lords, I'm going to short-circuit this point for two reasons. One is impending lunch, and the other is that it's set out in the written case. The third reason is it's probably not needed in terms of the analysis. Can I point you to where I deal with this?
In your case?
In my case.
Yeah.
It is paragraph 162, and I'm comparing in that paragraph the wording in the New York Convention with the wording in the other United Nations documents. The two significant ones to compare are the 1985 UNCITRAL Model Law on Arbitration and the 2010 revised UNCITRAL arbitration rules that were adopted by the United Nations last Friday. The revised UNCITRAL arbitration rules. And I've set out there the references to the current, hopefully, all the materials there are in the authorities bundle, together with the working documents that have come out from last week, or week before, from UNCITRAL. There is a distinction in these UNCITRAL documents between law and rules of law, but I'm going to park, with your permission, the point there. Perhaps most importantly, it's not needed in terms of the analysis.
Well, thank you very much. Does that bring your submissions to an end, or are you just simply playing for lunchtime?
Well, I can carry on now, but, my Lord, the one area, which is, of course, perhaps even the more significant area, because I changed my course because of the way that the argument had gone, I still need to cover, but I'll do as quickly as I can, is actually to give you my summary points. There are 7 of them, as to what is the nature of the
exercise
examination.
is. Yes.
Nature of the exercise. I'm in your hands in terms of timing. I apologise, it's taken longer this morning, but the points are complex points. The 7 points that I wish to cover are all set out in the written case.
Well, we've got, according to my watch, we've got about 3 minutes before 1 o'clock.
Can I at least set out the points?
Yes, please.
And then, after lunch, with your permission, I will canter through them.
Yes.
Now, the question we are, this will envelop...
Sorry, they're in the case now? They're in the case.
The 7 points are as follows. Can I just introduce what the issue is?
If you could just tell me where it is in the case, and I can follow
Yeah, it goes from paragraph 200. The issue is, what is the nature of the court's examination? Dallah says it is not a rehearing de novo. It is some lighter form of review or something else. The government of Pakistan's case on this is paragraph 233. It's the one in bold, which I highlighted yesterday. That is our answer. It's our formulation of what we say the nature of the examination is. That formulation is derived from 7 propositions.
Yeah.
The 7 propositions are as follows. Number 1. A full rehearing is needed because of the very nature of Article 5 of the New York Convention and its function. That argument is in paragraphs 200 to 206 of my written case. Point number 2. A full rehearing is needed because of the nature of the doctrine, and I'm calling it this, but by reference to yesterday's discussion, we shouldn't anymore, competence. Because of the doctrine of competence, Article 5.1a requires a full review, a full rehearing by the court.
Well, basically bootstraps.
Bootstraps.
That's right.
Bootstraps. That's paragraphs 207 to 221 of my written case. Your Lordships yesterday asked me, as one of the items to address competence. I did so in a rather rushed way yesterday. With your permission, but briefly, I will just give you some references to make sure...
Well, are you going to give us the 7 points?
I'm going through... I'm not doing it now. I'm just telling you...
Yes,
I'm just foreshadowing. I'm threatening what may happen after lunch, I suppose. What I want to do is to make good the variance between Germany, France, United States, England, and what the English doctrine is.
Well, let's come back to that afterwards. I just want to be sure if we have the 7 points before we rise.
Number 3, a full rehearing is required as a matter of statutory construction. That is, construction of Section 103(2) of the 1996 Arbitration Act and the New York Convention itself. That is in paragraphs 222 to 227 of my written case.
Yes.
Fourthly, because the precise definition of an extrinsic form of review or a lighter form of review is difficult to articulate and unworkable, i.e. the alternative is unworkable. And that is in paragraphs 228 to 233 of my written case. Fifthly, a full rehearing is consistent with the New York Convention scheme overall. And by that I mean the relationship in the New York Convention between the courts of the seat and recognizing and enforcing courts. There's a balance between them in the New York Convention, and that allows for a full rehearing at the stage of recognition and enforcement. It requires that. And that is in paragraphs 234 to 248 of my written case. Sixthly, because a full rehearing is the prevailing approach in all other major arbitration jurisdictions. And
Well,
there
that'll
I've
take
listed-
us several days to get through, wouldn't it?
I can, well, they're all in my written case. I'm giving you the paragraphs.
I think, well,
The authorities are on Article 51A, all point to a full rehearing. There's no authority actually supporting Dallah's suggested form of review. Paragraph 249 to 266 of my written case. And lastly, insofar as there is any energy left, because a full rehearing is consistent with current theory on international arbitration, something which the English courts have not frequently dabbled with. And that is paragraphs 267 to 273. There are prevailing theories of arbitration, Monsieur Gaillard, Mr. Poulsen, many others, and all of those, they disagree on many things, but they would agree on a full rehearing. Now, that can be done in 2 minutes or 10 days, but it's all set out in the written case, and I, of course, will be guided by the court as to what it may need assistance on.
Well, I must say, having read the case, it's pretty thoroughly set out, so I doubt whether you really need to go over all this ground again. How much longer are you proposing to address us after lunch?
Again, I'm in your hands. I'm conscious that my learned friend must have a reply.
Indeed, yes.
That we will sit from 2 till 4, that perhaps I should give her an hour.
Certainly.
So if I were to limit myself to an hour,
Well,
and maybe you would want me to be less.
well, if you can be less,
Yes.
so much the better.
And that hour is going to be on competence?
No, it'll be the hour. You have a menu of 7 items.
Oh, you want to look at
I'm in your
further
hands.
seven
as to
items?
whether
I
you
think
need
we should take
assistance on all
these
of them.
in. I mean, you're just going to be repeating what you've written out in the case, I think.
Exactly. So why don't I, in that time, over lunch, take a view as to what may
I
need
think you
further
should.
elaboration?
I think you should do that.
Certainly.
And we can read this at greater
Certainly.
leisure and look at the various papers.
Certainly.
Very well. 2 o'clock.